The February 10th, 2021 meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Peter Owen and members Judy Freshman, Paul Melnick, and Portia Clark. Also present is the professional staff, including Stephen Rizzi, coordinator for the BZA, Arlova Baum, zoning administrator, Mark Hamela, zoning technician, Blake Bowen, assistant to the zoning administrator, Cliff Hogan, assistant to the zoning administrator, and Kevin Black from the county attorney's office. For the safety of our board members and county staff, applicants, and participating community members, we are a virtual meeting today and all participants are joining remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance adopted in March of 2020. We thank you for being here and extend a warm welcome. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals, and then some ground rules on how we will conduct virtual meetings. The staff report for each case on tonight's agenda can be found on the BZA website. Staff has placed a link to the agenda in the chat section of the session. If you have not seen the report for your case, you may wish to review it before your item is called. Staff has also placed a link in the chat for supplemental material received after the staff reports were prepared. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modification of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. 2, we can grant variances from the specific requirements of the zoning ordinance. And 3, we can decide appeals of the decision of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets certain conditions and that the use permit will not adversely affect health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether modifications promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by preponderance of the evidence that the improvements meet the following criteria. The strict application of the zoning ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or that the granting of variance would alleviate a hardship by granting a reasonable modification to property or improvement thereon requested by or on behalf of a person with a disability, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. That the variance granted will be of substantial detriment to adjacent property and nearby properties in proximity of the geographic area, that the condition or situation of the property concerned is not so general or recurring in nature as to make reasonably practical the adoption of an amendment to the ordinance, and that granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process provided for under the zoning or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. The order of our meeting is as follows. First, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff that they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any speaker, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient: 20 minutes for applicants of appeal, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information they need and has discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. An appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Now I would like to briefly orient everyone to our virtual environment and to cover a few specifics on how this evening's meeting will run. Tonight's meeting is available to stream from the county website via a Microsoft Teams link. There's also a dial-in phone option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during today's meeting, please reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off sound to any other devices around you to minimize interference. For guests joining us via Teams, please turn off your video feed. Only board members will leave their cameras on. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on your meeting command bar. The moderator does not have the ability to unmute you. If you are dialing in by phone, press *6 to unmute. The meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Board members will ask to be recognized either by seeking recognition verbally as usual, or we also have a raised hand function that they may use. In either case, once you have been recognized, you may unmute yourself. All voting today will be taken via roll call. To applicants and public speakers, you will be called upon by county staff at an assigned time. Pre-registration to speak at today's meeting was requested. We will accommodate any additional speakers only if time permits. Public comment will be taken within the time frame stated earlier, the same as we would provide at an in-person meeting. During public comment, a speaker timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we will provide you an audible warning when 30 seconds are remaining. You will be muted when your time has concluded. Lastly, this is a public forum. Today's meeting will be recorded and posted to the county's website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. This concludes the introductory remarks. So before we have colleagues, we have 4 cases that are on our agenda that we will not be able to hear tonight due to defects in the meeting notice process. I would like to ask for unanimous consent to move these four agendas to the top of, to move these four items to the top of our agenda. Are there any objections? All right. We may defer these items to a separate meeting before which the proper elements will be completed. So I want to name the four cases that we are moving to the top of our agenda, and that is V11621-20-UP-1, 2307 North Buchanan Street, V11623-20-UP-1, 2419 North Ohio Street, V11624-20-UP-2, 1702 North Cameron Street, and V11625-20-UP-1, 5954 10th Road North.
Madam Chair,
Mr. Owen.
I believe you misspoke on the first one in stating the address, which is 2307 North Burlington Street.
Burlington Street, thank you. Mr. Rissy, we'll call these items one at a time. And if board members have any questions that they'd like to put into their record, we'll allow time for that, as well as if there are, we will determine if there are any speakers that wish to speak before we vote on the item. So, Mr. Rissy, you may call the first item, which would be the North Burlington Street item.
Yes. Case number V-11621-20-UP-1 is a use permit request by Stephen Tinter on behalf of the owners, Caitlin Brock and Christopher Brock, to permit a left side setback of 5.1 feet to the wall, 4.6 feet to the eave instead of 8 feet to the wall, 5 feet to the eave as required from the left side property line, and to permit an aggregate side yard setback of 15.1 feet instead of 18 feet as required in the R6 zoning district, regarding new two-story rear addition to an existing one-family dwelling in the R6 zoning district on the premise known as 2307 North Burlington Street. Staff recommends the board defer the subject use permit request to a special meeting of the BZA.
Thank you, Mr. Rissy. Are there any questions that we would like to put into the record on this item?
Madam Chair,
Ms. Freshman?
I wondered if you were going to set the date, and second question was, if it's only 2 weeks, should we keep our reports?
Mr. Rissy, I believe our board members are available on the 24th. Is the 24th suitable date for you?
Yes, Madam Chair. We'll make that
Okay, so when it's time, we can make a motion to defer to the 24th of February. Any questions that we want to put into the record?
Madam Chair,
Mr. Owen?
I just note that the staff report has a discussion of certain, what it refers to as non-conformities on this parcel. And I hope that the staff might be able to expand on that when we next hear the item. I've submitted staff some written questions in this regard, and if the applicant hasn't seen them, they can see them as well, but they're mainly questions for staff. In fact, that's easier to do after our appeal is concluded tonight, because that's going to explore some of the same issues.
Okay.
So I don't need any feedback tonight, but I'll just note that I've submitted questions to staff.
Okay. Anything else? Is there anyone here that wishes to speak to this item? In that case, we can make a motion.
Madam Chair,
Mr. Owen?
I move that we continue this item to a special meeting of the Board of Zoning Appeals to be held on the 24th of February.
I'll second.
Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to continue this item to our special meeting on February 24th, passes 5-0. Next item, Mr. Rizzi.
Next item is case number V-11623-20-UP-1. It is a use permit request by Tim Vandano on behalf of the owners Megan and Patrick Kennedy to permit a street setback of 20.9 feet to the porch from North Ohio Street instead of 21 feet to the porch as required, to permit a rear setback of 10.1 feet to the rear addition, 8.7 feet to the eaves from the rear lot line instead of 25 feet to the wall, 21 feet to the eaves as required, and to permit a rear setback of 15 feet to the landing, 9.3 feet to the window well from the rear lot line instead of 21 feet as required, regarding a proposed two-story rear addition and side additions with front porch to an existing one-family dwelling located in the R6 zoning district on the premise known as 2419 North Ohio Street. Staff recommends that the board defer the subject use permit request to a special meeting of the Board of Zoning Appeals on February 24th, 2021.
Second.
Whoop, that wasn't a motion.
Oh, sorry. Oops.
Oops. Are there any questions that we would like to raise at this time?
Madam Chair,
Mr. Owen?
some questions I would have that we can hear the answers to, hopefully in writing before the next action on this item. It wasn't clear to me whether or not the applicants agreed or disagreed with staff's proposed alternative resolution of 12.6 feet, or indeed whether the staff would support that. Commonly that's the case, but it just wasn't clear from the submitted materials. A bigger issue is that this property abuts an alley, and it wasn't clear to me who owns the alley, whether it's a public right-of-way, whether or not the rear lot lines examined on page 3 of the staff report abut alleys, or rather other normal parcels, and whether the staff analysis took into consideration the fact that the rear lot line abuts an alley rather than another residential parcel. I also was curious about the difference in analysis between the Ohio Street case and a different case tonight on, I believe, First Street, 11619, in which the staff, in that other case, the staff report found that the unusual relationship between the edge of the property and a right-of-way to be very significant, indeed so much so that the staff did not present a table, as it did in the Ohio Street report, of setback surrounding properties, whereas here, the presence of an alley is not even mentioned in the staff report for this parcel. And I'm curious as to why there was not the same approach taken in both staff reports. So perhaps staff could examine that and come back to us with some guidance about when we do and do not consider whether or not the setback is such as an alley. Thank you. Oh, and I'll also say I did also have some questions earlier in the week about whether or not the Kellys or Kennedys approved the application and the agent, but that seems to have been resolved now with the supplemental materials we received.
Ms. Clark, do you have your hand up? You're muted. Nope, you're muted again. You're mute.
Okay. I believe when Mr. Rizzi called the item, he stated V1162120UP-1. I have UP-3.
Sorry, this item is case number V-11623-20-UP-1.
Okay. All right, sorry.
Does that clear it up? Is there anyone here that wishes to speak on this item?
Madam Chair, I think Mr. Melnick had a question.
Oh, yes, Mr. Melnick.
Yes, so I have a question. So I did see the supplemental materials name, where the owners named Tim Vanvano as their agent. But I noticed that the disclosure statements, what appears to be signed by a Carl Vanvano. And I would just, ask the applicants to clarify, like, is this going to be like a general, is the agent really the company where Carl and Tim and sign things on their behalf, or, 'cause I'm looking at the notary on the disclosure statement where it mentions Carl. So I'd ask the applicant to tie Carl in somehow. If he's their agent, then, let us know. Do you all see?
Mhm.
Okay.
Ms. Clark? Would you? Anyone here wish to speak on this item? I'll like a motion.
Madam Chair,
Mr. Owen?
in case V-11623-20-UP-1, I move that the Board of Zoning Appeals continue the item to a special meeting of the BZA to be held on February 24th.
Second.
Seconded by motion made by Mr. Owen, seconded by Ms. Freshman. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to continue this item to February 24th has been approved. Next item, Mr. Rissy?
Yes, the next item is case number V-11624-20-UP-2. It is a use permit request by Stephen Tinter on behalf of the owners Theodore and Karen Bloss to permit a street setback of 15 feet to the wall, 13.3 feet to the eave from North Cameron Street instead of 25 feet to the wall, 21 feet to the eave as required, and to permit a rear setback of 8 feet to the wall, 6 feet to the eave from the rear lot line instead of 25 feet to the wall, 21 feet to the eave as required, regarding a new two-story front-sided addition on a split zone property in the R5 and R6 districts on the premise known as 1702 North Cameron Street. Staff recommends the board defer the subject use permit request to a special meeting of the Board of Zoning Appeals on February 24th, 2021.
Thank you, Mr. Rissy. Any questions we'd like to put into the record?
Madam Chair.
Mr. Owen?
I did submit to staff some questions about this application, including questions about the ownership of Outlot A, whether or not there is any government ownership of that lot, public ownership of that lot. It's unclear to me where the zoning boundaries are between R5 and R6 in this neighborhood, and so a zoning map clarifying where the zoning boundary exists on this project would be helpful. It's not clear to the staff report seems to say in its text that the proposed addition does not extend into Outlot A. However, some of the drawings we've seen do suggest that it extends into Outlot A. So some further clarification about whether or not the project in part intrudes on Outlot A would be helpful. And then finally, there's some written feedback from affected neighbors, or possibly affected neighbors and certainly adjacent neighbors that seem to be missing from the packet, most significantly the neighbor at 4944 17th Road North, but also there are adjacent parcels at 4805 and 4809 17th Street North. And so maybe the extra time will allow some opportunity for clarification, either to get written feedback from those neighbors or a clearer explanation of what the outreach was and why written feedback was not obtained. So those are my questions.
Thank you, Mr. Owen. Any other? I have one, Mr. Rissy. I think we have supplemental material that has an additional proposed site plan. If you could clarify that for next time, if this is now part of the packet and what the significance of this plat is compared to the one that's in the current staff report. All right, are there any speakers? All right, I'll take a motion.
Madam Chair.
Mr. Owen?
I move that in case V-11624-20-UP-2, that the Board of Zoning Appeals continue this item to a special meeting to be held on February 24th, 2021.
Second.
I'll second.
Who seconded? Ms. Clark?
Yes. Yes.
All right. Motion made by Mr. Owen, seconded by Ms. Clark. Any further discussion? I see a hand up.
Yes, hi, this is Steven Tinter. I'm sorry, I didn't get it quick enough when you asked if there was any feedback. I was
Okay,
looking for the hand,
go
but all I wanted to do is, I'm the agent for the applicant of two of the four projects that weren't advertised correctly this month, and I just wanted to thank the board members for agreeing to do a special hearing for those rather than just pushing them off to the March hearing. We really appreciate it because there are some time implications for our homeowners. So that was all I wanted to add, is just to thank you guys for accommodating that.
Thank you for saying that, Mr. Tinter. We appreciate it. We have a motion made by Mr. Owen, seconded by Ms. Clark. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to continue this item to the February 24th meeting has been approved on a vote of 5-0. Mr. Rissy, will you call the next item in this group?
The next item and last in this group is case number V-11625-20-UP-1. It is a use permit request by Tim Vambano on behalf of the owner, Regina Petschke, to permit a setback of 21.4 feet to the wall instead of 25 feet as required from North Madison Street, and a right side setback of 6.5 feet instead of 8 feet as required to the interior property line, regarding one-story side addition and new front porch on an existing one-family dwelling on a corner lot in the R6 zoning district on the premise known as 5954 10th Road North. Staff recommends the board defer the subject use permit request to a special meeting in the Board of Zoning Appeals on February 24th, 2021.
Any questions we'd like to put into the record? All right. Any speakers on this item? Oh, Mr. Melnick.
Yes, so I have the same issue as on that previous one where Carl Von Vano signed the disclosure statement, but Tim is listed on the application as the agent. So just clarification on that.
All right. Thank you.
All right.
Any speakers on this item? I'll take a motion.
Madam Chair,
Mr. Owen.
in case V-11625-20-UP-1, I move that the Board of Zoning Appeals continue this item to a special meeting of the BZA to be held on February 24th.
Is there a second?
Second.
Motion made by Mr. Owen, seconded by Ms. Freshman to continue this item to the February 24th meeting. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark? Ms. Clark, you're muted. You're frozen. She's frozen. All right. I think we're going to have to just go, chair votes aye. So we have 4 aye votes. If Ms. Clark doesn't come back, can we count it as an abstention?
That seems, well, I would say just not present.
No vote, not
Out of
present.
the room.
Not present, right. Okay. Motion to carry this item to the February 24th meeting passes on a 4-0 with 1 not present. That concludes this group of items. I'd like to get Ms. Clark back into the room. There she comes.
Yes, I'm back.
You're back? Okay.
Yes.
All right. We, just as information, we counted you as not present in the last vote,
Okay.
but you're with us now. Mr. Rissy, will you call what is, I guess, the first item on our agenda?
Yes, case number V-11626-20-UP-2 is a use permit request by Stephen and Tracy Butelli, the owners, to permit a rear setback of 2.5 feet to the wall of the rear detached garage, 2.3 feet to the eave instead of 10 feet to the eave as required, regarding an unbuilt rear detached garage expansion previously approved by the BZA in 2017 on existing garage in the R10 zoning district on the premise known as 2012 South Arlington Ridge Road. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Mr. Rissy, I want to note that while the use permit request line states that it's Tracy Butel, I think in the staff report on the top line, an applicant is Kelly. I believe Tracy is the name on the disclosure statement.
Madam Chair, staff agrees with your analysis that Tracy Butelli is the name on the disclosure statement, and the staff report does have a Kelly listed.
All right, I don't think that's relevant. You know, the fact that the staff report has an error is relevant.
I don't believe it's a critical error or omission in the notice, Madam Chair.
Okay. Any other questions for staff? Are the applicants Stephen and Tracy Butel with us tonight? And if you are, you can turn on your video and mic.
Yeah, this is Stephen Butel. I'm with you.
Hello.
And thank you. Can you hear me?
Yes.
Okay, I'm Stephen Butel, and my wife's name is Tracy. So we've done this once before. Mr. Harold Left is representing me on this. He's my general contractor and carried this through back in 2017. We did not complete it or start it because, of course, the last 18 months, 2 years, we've been doing other things with COVID. So we're reapplying for it. I would say one thing. I bought this house, it's 30 years old, and I've been remodeling it for 10 years. The one thing I didn't notice, my wife reminds me, is that cars are a lot smaller in 1930 than they are today. You cannot put a full-size car in this garage, okay? And she reminds me of that periodically. So what I've asked to do is push the back of it out 10 feet so we can actually put a full-size car in the garage and be able to walk around them and put my tools and lawnmowers and other things in it. But I'd like to turn over to Harold Leff, who's my general contractor, and I did submit to Mr. Misa a package allowing him to speak for me since he's been through this before, and he also has done the designs before, and those included in the package.
Thank you.
Good evening. I am Harold Leff. As Steve said, the house was built, I believe, in the 1930s, along with the garage. So this thing is about 80 years old, going on 90 years old. And the walls, overall depth is 20 feet, but the walls are a foot thick each. And so you've got about 18 feet. When you pull a car in, you have to barely squeeze by. So we're asking to extend it out the back 10 feet, just so that the cars will be able to live in there, so that Tracy can actually get her car in.
Is this the same application that you submitted?
Yes, it is.
Several years ago? There's no changes to the drawings or content.
I used the same drawings as before.
Okay. Any questions for the applicant,
Madam Chair.
Mr. Owen?
Who is the neighbor at 1313 21st Street South, the next door neighbor?
That would be Alyssa Doyle.
And has Ms. Doyle signed off on this? Does she have any written feedback or comments on this application?
It's right here. I don't know if it didn't get into the package or not, but Alyssa has signed off on the 23rd.
Thank you.
Can you hold that up for us a moment? Just so we can look for it.
Mr. Rissy, do you have a copy of what the applicant is showing right now?
You can,
It's the page titled modification in large letters.
and it's Jane Doyle, is that the name?
Alyssa, A-L-Y-S-S-A.
Okay.
If you don't have it in your package, I can forward it tomorrow or today or.
You can shoot a copy of it, yeah, and forward it to Mr. Rissy.
I'm sure I put it in. She put a handwritten note on it as well. And I was sure I had it in the package, but if it's not there, we'll just send it to you again.
Yeah, it'd be great to have it in the record.
Thank you. Any other questions for the applicant? Are
Madam
there,
Chair,
Mr. Melnick?
I'm prepared to make a motion.
Let me just make sure there's no one else here wishing to speak on this.
Okay.
I'm asking now. I don't hear any, so go ahead, Mr. Melnick.
Okay, so in case D 1162620 UP2, I move that the Arlington County Board of Zoning Appeals grant a use permit request with the conditions as stated, including a condition that the building permit must be applied for within 3 years.
Second.
So new condition number 4.
Mm-hmm. Right.
Okay. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to grant the use permit succeeds on a vote of 5-0. Thank you very much. Good luck.
Thank you, board.
And this is Steve Motel. Just a quick comment.
Yes.
I know you have a new software system over the last, I don't know, few months. And as I uploaded this and worked with, I have to say that Mr. Reese's people that helped me, called me, and supported me as they worked into this thing were absolutely superb. And they do great work, and they really helped bring in the new system.
Thank you very much for saying that. Very much appreciated. I know changing over to new systems isn't easy for anybody.
No, I'm in the software business. I understand that. So, but if it all worked perfect, I'd be unemployed.
All right. Well,
Thank you.
Mr. Rissy might call on you someday. Thank you very much. Mr. Rissy, will you call the next item?
Yes, Madam Chair. The next item is case number V-11601-20-APP-1. It is an appeal by Rebecca Hunter, the property owner, of a zoning determination addressing zoning relief needed for a proposed re-subdivision of the property at 4313 4th Street South, located in the R6 zoning district. Staff recommends that the board adopt the attached proposed resolution affirming the zoning administrator decision. And I'd like you to please note that we do have an additional speaker who has signed up to speak on this item.
Thank you. Is Mr. Lawson with us?
I thought I saw.
Not on.
Yeah, there he is.
Okay. All right. So, Mr. Alova, Mr. Alova, Ms. Vaughn, you may proceed.
Both work. They're both accurate. I have very brief comments. I'm not going to come close to the 20 minutes. But just a few summary items. So on May 11th, 2020, the appellant requested a determination regarding a proposed re-subdivision of the subject property and an adjacent property at 304 South Taylor Street to create 2 new lots, referred to on the plat included in the documents as Lot 550 and Lot 506. And this would be accomplished by reducing the size of the subject property and combining the portion reduced with the adjacent one at 304 South Taylor. A determination on this subdivision request was issued on July 1st, 2020. Subsequent to that, the agent for the appellant requested a second determination for the subject property, specifically asking about how the existing improvements, a single-family detached dwelling, and accessory structures would be treated if the property were re-subdivided. A determination was issued on September 8th, 2020 in response to this additional request and is the subject of this appeal. The September 8th determination stated that the proposed re-subdivision to create a new Lot 550 would require a variance due to substandard lot width, as well as use permits from the Board of Zoning Appeals for existing non-conforming buildings and structures which do not meet standards for location requirements. The proposed re-subdivision would result in the reduction of lot area, which triggers analysis under ACZO section 3.2.3.b, which stipulates that no lot shall be reduced in area except in conformity with all area and building location, bulk, placement, and coverage regulations. Because the appellant is seeking approval for the creation of a new, smaller lot, the requirement of ACZO 323B necessitates that all structures, including existing ones, meet location standards. The statement of support provided in the appeal, found in attachment 4, states, "This is regarding the necessity of obtaining a use permit for non-conforming buildings and structures for the creation of an outlot on the property located at 4313 4th Street South, Arlington, Virginia, 22204. 22204, excuse me. While the appellant provided a copy of another appeal application as an exhibit, it was never formally filed with the zoning division and is not the subject of this appeal, nor is it addressed in my comments. The appellant indicates also that the past practice of the zoning division has been inconsistent on this matter, but to date has not provided evidence of this, so I have no response to those, to that line of questions that were posed. So in closing, I would say that staff requests that the BZA uphold the zoning administrator's decision in the September 8th, 2020 determination.
Thank you, Ms. Vaughn. That concludes your presentation?
Yes.
Thank you. We will hear from the appellant, and I believe that's Mr. Lawson.
Yes, ma'am. Can you hear me okay?
Hear you great.
Good, good. Sorry, my Zoom quit working this afternoon. Again, thank you for deferring this from the last month. That was pretty, we were pretty late and I was really having trouble focusing. I'm doing this appeal to address a problem that I've seen through the many years that I've been doing this, and hopefully clarify the process for the future. You know, there's no house at risk of being torn down. We don't have a lot that won't be buildable, but, you know, I would submit this is still important that we address this. I want to point out that Arlova has been terrific to work with, and you know, she's doing the best she can with what are frankly conflicting and confusing ordinance provisions. So I wanted to point that out. And you know, I used to be on the Planning and Zoning Subcommittee of the Civic Federation, and they were struggling with issues like this. And I think somewhere we discovered that 50% of all single-family homes in Arlington are in some way non-conforming. And so I had included an article from the Arlington Magazine dealing with some of the problems that our fellow citizens encounter when they try to put on additions and so forth. With respect to Arlova, I don't think we need more bureaucracy and more applications and more filings to do what I think is a pretty simple thing. Now, Arlova is citing 3.2.3. You all have seen that language. And frankly, I don't even know what it's saying, to be honest. There's a sentence that Arlova did not quote. It says, "No open space surrounding any building shall be encroached upon or reduced in any manner." Well, heck, that's not being enforced. If it is, it would be enforced on every case where anybody's ever adding living area, because open space surrounding a building would be encroached upon or reduced. And in the written materials that I submitted, I had suggested that the only way this can make sense is if you're dealing with going under the minimum required area. And this, the code section or the ordinance section is lot area, comma, minimum. And so I would respectfully submit that we're not dealing with going under the minimum lot area. What we have is a situation where we have a lot that is under width. And that section is 3.2.4. And it says no parcel of land held under separate ownership with or without buildings on July 15, 1950 shall be subdivided, re-subdivided, or reduced in any manner below the minimum lot width and lot area required by this ordinance. And again, these are very confusing sections. You know, under lot width, why are we talking about lot area? But that's what the language says. And so I submit that the only way we can make sense out of these is that you're not allowed to go under the lot area. You're not allowed to go under the lot width when you subdivide. And I think in addition to the sections dealing with lot area, minimum, and lot width, there are other sections that you have to look at. And so when we look at these other sections, I look at some of the grandfathering sections, and we go over to 16.1.1, lots in R districts. And then it talks about where a lot has less width and or less area than required. And we corrected that not long ago because we didn't have and or. But it says that such lot may be occupied by any use permitted in the district. And the use being permitted is the grandfathered lot and the grandfathered house. When you look at the building, because we have two issues. One is, you know, the lot that's under width, and we have the house that's too close. And so when you look at buildings under the grandfathering provisions, we look at, it says continuation and change of use. And then it says except as otherwise provided in this section. And what it basically says is you can continue the use as long as you don't enlarge it or expand it. And that's kind of Hornbook law that we know about from looking at the state code and in law school learning about land use. And Arlington has adopted what the state code provides for the for grandfathered lots, and that is that as long as you you don't add on and make it even closer to the property line, you're free to take off some area in the back and convey it to another property owner. Let's see, I got one more thing I wanted to share. Let's see. When you, going back to the lot width and the lot area, you know, Arlova's taken the position that you can't reduce any lot ever. And, you know, I got to think about that. Let's say you're talking about Washington Golf Country Club. And let's say there's a shed on the, you know, too close to Glebe Road. And they want to, you know, carve off a lot to sell to a builder over on Military Road, all the way on the other side of the golf course. Under this interpretation, you can't do that unless you go get a use permit for the shed that's too close to Glebe Road. And I would submit that that just doesn't make any sense. And I doubt zoning, if something came in to carve that lot off, I don't think zoning would even take a look at that. Let's see, let me take a quick peek at my notes. You have a lot of written material, and just wanted to kind of highlight what I think is most important. You know, should you all be favorably inclined to go our way on this, I'd ask that your resolution make it clear that we can take off this rear part of the lot, and we don't need to get a variance because of the non-conforming width, and we don't need a use permit due to the non-conforming side yard setbacks. That's all I got. Like Arlova, I wanted to, you know, be kind of short, and I'll be happy to answer any questions.
Thank you, Mr. Lawson. I think we have a speaker, and then we will circle back with questions. Mr. Rissy, who's our speaker? Okay. Is Mr. Lamarand here?
Yes, Mr. Lamarand is here. Can you guys hear me?
Lamarand, yes, thank you. Do you have video?
I don't see anyone else's video, but I can turn mine on.
Okay, we see you. Yep.
Okay, great.
Welcome.
Thank you so much. So I am the potential buyer, and I don't have any legal arguments to make. I just, you know, wanted to give, I guess, my experience as a citizen and resident of Arlington County. My neighbor and I agreed to this conveyance because the property doesn't mean too much to my neighbor, but it's only about 20 feet away from my house. So it does to us. You can't see in the photo, but I have a chain link fence that goes across, I don't know how many feet of our border. And there's a lot of undergrowth and whatnot. We would love to just make that pretty. And we have small kids and use it. So it seemed like a win-win when we decided to convey the property. And as we've been dealing with the county, and I appreciate the county's done their best to interpret the code, the reason we've pursued, hiring an attorney and keep going is because every time we hear something, it doesn't make sense to us. As far as, we get lot coverage issues and we get setbacks, but an issue of like a non-conformance with a 55 or 50-foot wide or 50-foot wide lot is confusing. Obviously, that's not something we can remedy ever. And so to Barnes' point, it's confusing that you wouldn't ever be able to reduce even an incredibly large lot like we're dealing with here without a variance. And my understanding is a variance may be next to impossible. So, I respect everybody's, interpretation of the code. I understand everyone's trying to do their best, but, just from the citizens' perspective, we've been able to pursue this, or we keep pursuing this because it doesn't make much sense to us. And then finally, I'll just say there's very large trees that are next to our property. And obviously, like my children sleep on the west side, second story. Not that Rebecca, our neighbor, wouldn't manage those, but we've got a bigger interest than she does in making sure those don't fall on her house. So just another reason we like the property. I see my time's up. I'm sorry. I don't mean to abuse everyone's time, so I'll stop.
Mr. Lamarand, you live on South Taylor Street. What is your address?
Yes, 304 South Taylor Street.
30, sorry, 30?
4 South Taylor Street.
Okay. All right.
Yeah, there's a great photo where you can see the trees that kind of tower over the west side of the house.
Yeah, but I understand, you're not the applicant in this case. The appeal is.
Correct.
is-
Right.
Got it. Okay, good. Thank you.
I'd be a potential buyer of the outlot, I suppose.
Got it. Thank you. So I see Mr. Owen, you want to start off with the questions?
Yes, actually, I'd like to start off with a disclosure. When I visited this block, it just so happened that both Ms. Hunter and Mr. Lemran were home and outside of their houses. And both of them, seeing that I was from the BZA, invited me to go to their respective backyards and inspect the situation from the rear of their lots. And I accepted the invitation in both cases, but had no other substantive discussion with either party. So I just want to disclose that interaction with each of those individuals. And then I do have some questions. The first question would be for Ms. Vaughn, the zoning administrator. Mr. Lawson submitted in response to some questions that we had asked, a clarification of the issues for the BZA to decide, and he stated them as 2 issues. 1, whether a variance is required to re-subdivide the property because the remaining parcel would continue to be less than 60 feet wide. And 2, whether a use permit is required to re-subdivide the property and retain the existing house in its current location. Do you agree that those are the 2 issues the BZA has to decide tonight?
No.
What would you say the BZA has to decide tonight?
The issue that I'm responding to is the request in the second determination, asking specifically about whether or not use permits are necessary under a proposed re-subdivision for the existing buildings and structures.
I see. So you have not yet issued an opinion as to whether a variance is required to re-subdivide the property.
I did, but the appeal request didn't reflect that.
Oh, I see. You're saying that it's a matter decided whether the variance is required.
Yes.
I'd like to speak to that if I could.
Well, Mr. Lawson will give you a turn when Mr. Owen's done.
Okay. And in that case, then, I have some questions about the applicability of 3.2.3 versus 3.2.4. Does one of them apply to the building and the other apply to the lot severance? Am I understanding that correctly? So 3.2.3b is the longer paragraph that says, among other things, no open space surrounding any building shall be encroached on or reduced in any manner. No lot shall be reduced in area except in conformity with all, et cetera, et cetera. That's in 3.2.3b. But then in 3.2.4b, there's another provision that says no parcel of land held under separate ownership with or without buildings shall be subdivided, re-subdivided, or reduced in any manner below the minimum lot width and lot area required by the ordinance except as permitted in 16.5. So are both of them relevant? Is only one of them relevant? Is only one of them relevant to the use permit question versus the variance question? That's my.
So again, I'm only speaking to what was asked of me, which is regarding use permits. And I would say 324B is about lots, not necessarily about structures or buildings on those lots.
Okay. Thank you for that clarification. And I'm happy to hear Mr. Lawson's version of those questions as well.
Go ahead, Mr. Lawson.
Thank you. What happened is the first letter or the first, when I requested the determination only dealt with the lot. It didn't deal with the building, and we needed a full determination. And so my understanding was that the subsequent determination would cover both questions. And I'd also point out that the Supreme Court of Virginia had told all deadlines. And so I couldn't legally be held to the 30 days. So when I got the second determination, which again spoke to both issues, then I appealed that. And I think both the lot width and the proximity of the house to the lot line are both properly before the BZA.
So, I think what we're trying to do is clarify what is before us. And there's definitely a difference of opinion on what it is that we are supposed to be ruling on. I believe Ms. Vaughn has a determination that we are reacting to. Is that correct?
If I may. The appeal application and the statement of justification in the appeal application specifically references the use permit. There was a second exhibit, I can't remember which number it is, as a part of that application that looked to be an appeal that was never filed. So maybe that was contemplated, but never actually filed. And it appears as though it was just added, and after the fact, we're now being asked to subsume one into the other.
So
again, the Supreme Court has told all deadlines. So the appeal was both issues.
Mr. Lawson, can you give us a moment to sort this out? There's two applications for an appeal. One is dated August 14th, and the other is dated August 5th. Do we agree on that?
I believe so.
Ms. Vaughn, do you agree with there's two applications in our packet?
Yes.
Okay. And the one that you are responding to is the August 14th one? Or the October 5th one?
The October 5th one.
Okay.
I never saw the one dated August, 14th until I received the one dated October 5th.
So you received those both at the same time?
Yeah.
So when you received these two applications, how did you decide which one you would respond to?
The one dated August 14th was past the 30-day deadline. And it appeared to be an attachment. And I think there's a statement saying we're incorporating it because of some of the arguments that are relevant.
Okay. Again, can I speak to this?
Anything you can add that will help clarify this would be appreciated.
I didn't file an appeal within 30 days to the first one because there was no point in having two separate appeals. And so I had understood from Ms. Vaughn that she was going to do a new determination and address both issues, and then I could file one appeal. And so I included the one that I was going to file earlier with my subsequent one. And again, the 30 days was told by the Supreme Court. So I respectfully submit both issues are in front of the BZA.
Well, the problem is, it seems that, what Ms. Vaughn is saying is that she has not responded to your August 14th issue.
Madam Chair, I believe Kevin Black from the County Attorney's Office has his hand raised. I'm not sure if he has something to add to this as well.
Mr. Black, welcome.
Hi,
and
Chief. Thank you very much.
clarification.
Thank
Yes.
you, Madam Chair. I just wanted to point out to the BZA that it's my understanding that the emergency order that was issued by the Virginia Supreme Court applied to the district and circuit courts. I don't see any information that it applied to a body such as this. So I just wanted to make that clarification.
Thank you, Mr. Black, but don't go away.
Oh, I'm here.
Um,
I'm sorry, Madam Chair, could I ask Mr. Black to elaborate on why he thinks the Supreme Court's order was limited in the way he described?
It's based off of my memory, having reviewed it or seen it, that it applied to the district and circuit courts. So I'm happy to try to pull that up for you if I can.
That might be helpful because arguably we're an instrumentality of the circuit court.
I respectfully disagree with that, but let me try to pull this up.
So, I'm not sure, Mr. Lawson, I'm not sure how Ms. Vaughn can, has not responded to both of your issues, so I'm not sure how we can adjudicate both issues.
Well, if it needs to be deferred to the special date that you all have, that would be okay, and she could respond to it. Her determination does address both issues, and so I thought I was safe in filing the appeal that I did, confronting both issues.
Madam Chair.
Mr. Owen.
May I suggest that we continue on the presumption that both of Mr. Lawson's issues are in play, because I think how the BZA would see them substantively may play into how we can efficiently resolve this procedural dispute.
All right. Thank you, Mr. Owen. Mr. Black, do you want to comment?
Again, I don't think that his appeal on the other issue is properly before the BZA. And so I don't think that entertaining it serves a purpose, and I respectfully would state that I don't believe it's proper.
I think we're, sure, I think we're noting the objection. I don't think we have to dispose of it before conducting the rest of the hearing. We do have to dispose of it tonight, but I think it might be helpful to proceed noting the objection and just see how the rest of it's playing out, because I think there might be an efficient way to handle it.
Well, I would respectfully also add that it is at least, somewhat prejudicial to my client to have to defend something that, frankly, we thought was clear beyond the 30 days was not before this body.
Yeah, I guess I would also say that the BZA asked the county, the zoning administrator specifically in writing months ago to clarify the issues that are before the BZA to decide. And the zoning administrator declined to provide any supplemental clarifying material in advance of the hearing tonight. And so that would have been very helpful in order to expose this disagreement. And we might still decide not to decide the variance issue for the reasons that you've objected to, but we have, we can't just take your word for it about what the issues are before it. We have the other side disputing it, and I would say, for the sake of efficiency, that I would recommend to the chair that we continue to discuss the issue substantively, because I think that we might be able to achieve a fair and efficient resolution, including deciding this disputed issue of whether the variance issue is even before us, after we hear substantively from each side. understanding that Mr. Black and Ms. Vaughn do not come tonight prepared to discuss the variance issue.
I would add one more thing, if I may, is that we actually did state clearly in our response and in our materials that this appeal wasn't filed timely, and therefore it is not before this body. So just to address that point.
The determination on the lot width was repeated in the subsequent and second letter. And so when I appealed the second letter, I also appealed the lot width. That letter says, as the proposed subdivision would not resolve the existing non-conforming average lot width of lot 550, an average lot of 50 feet would be considered not compliant with the Arlington County zoning ordinance. The proposed re-subdivision cannot be carried out by right and would require relief from the minimum standards, which necessitate an average lot width. So that's in the second letter. So that's part of the determination. I appealed it.
Madam Chair, I would just suggest that we note that this is something we have to figure out, but move on to the subject.
I agree. Yeah, we are going to, at this point, gather people's thoughts, and then we'll decide how to sort them out and whether we can sort them out tonight.
Madam Chair, I have an additional substantive question.
Mr. Black, do you have your hand raised? I don't know if you.
I'm sorry.
Okay, I just.
Unintentional.
Thank you.
Sorry.
So, Madam Chair, one of the other questions I asked related to a comparison to 16.5.2, another section of the zoning ordinance that, Mr. Lawson, I concede that 16.5.2 does not directly apply to this situation. But the reason for my question, which I had asked here in writing, was that the language there specifically uses construction, the condition that was not created or furthered by the acquisition of the county. And so to me, that suggests that the county board, in crafting language in the ordinance, knew how to write an ordinance provision that talked about whether or not the change furthered the non-conforming condition, but chose not to use such language in 3.2.3, 3.2.4, or the other language at issue in 16.1 and 16.2. So that was the focus of my question. How come we should still find that implication of the furthering of the nonconformity matters when the county used starkly different language in 3.2.3, saying things like in any manner and no lot shall be reduced in area. It didn't say except when the nonconformity is not furthered. So can you address the distinction in construction between those two sections of the same ordinance?
Yeah, Mr. Owen, what's that code section? I've got juggling all these things, and so I didn't.
It's
the ordinance
16.2, sorry, 16.5.2, and it's the last half of that sentence. 16.5.2.
I don't know what that means, really. I mean, it doesn't make sense. It's saying that you can't confer non-conforming status on any condition that was not created or furthered by acquisition by the county, and yet you could have plenty of non-conforming lots that were created through the years. And so I don't know how the county can say only by their own action can something be non-conforming. It could be non-conforming due to the fact that it was done before a change in the ordinance.
Well, no, that's not what I'm getting at, Mr. Lawson. In another question, you conceded that if the lot width were being reduced or the setback were being reduced, that a variance or a use permit would be required. That was part of your response.
Correct. Absolutely.
And so your main argument here is this applicant, Ms. Hunter, is not reducing the lot width and she is not reducing the setback. And
Correct.
So even though she's reducing the size of the lot, she's not reducing the non-conformity. She's not
right.
affecting
And
the nature of the non-conformity.
Right.
She's not furthering the non-conformity. And
right.
what I'm asking you is, since the county board appears to clearly know how to describe the situation of furthering a non-conformity, the language they use in 16.5.2, they didn't use that language in 3.2.3 or 3.2.4. Why shouldn't we draw the inference that they meant something different, that they really did mean categorically any reduction, not just reductions that increase the nonconformity?
I appreciate the question. My response would be, okay, if you're if that's your determination, I expect from now on every land use application that comes before you that reduces the open space around a building, that section will be applicable to that as well. I don't think it's applicable to this case, what Arlova is citing. I think what's applicable is the sections in 16.3 that talk about as long as it's not being expanded or enlarged, a non-conforming situation can remain. Looking at 16.1.1, if you have an undersized lot, then you can have any use permitted in their district. And the use permitted in the district is to have a non-conforming house. So I think that's covered there, and I think it's covered on the buildings where it talks about buildings, and it says they can continue, and then it says expansion prohibited. So as long as we aren't worsening the situation as far as the structure, it can continue.
Thank you. I would ask if the zoning administrator has any reaction to that colloquy mentioned.
Ms. Vaughn, are you still with us?
I'm having a hard time following, quite honestly. I would say generally a couple of things. We are looking at and talking about a couple of different sections that refer to slightly different scenarios. So, and all of them can be true at the same time. So certainly there are, in the non-conforming article, scenarios where we have provisions that allow both non-conforming uses and non-conforming buildings, or some combination of the two, to remain under certain sets of circumstances. And that's, I would agree with what Mr. Lawson said. But in this particular case, the request was for a re-subdivision. So it was a request to recreate a new lot, not simply to allow what has been there to remain. By the action being requested to create something new, the second part of that section, or perhaps the fourth part, it's a long section, which lists all of the parameters, says, you can't make something smaller in area unless it complies with all of these other standards. So I think we're talking about slightly different things, and they're addressed in slightly different places. And I would agree it is sometimes difficult for us to keep up with all these different permutations. The only other thing I'd say is we also have a section at the very beginning of the ordinance that says, where there are conflicts, the more restrictive rules. And so even if you feel like these are working against each other, the ordinance says we have to go with whatever the most restrictive requirement provides.
So,
Yeah, if I could add one thing,
Mr.
Peter, Mr. Owen.
Mr. Lawson, hang on one second.
Okay.
So 3.2.4 on lot width says that can't be reduced in any manner below the minimum, right? This is not reducing anything below any minimums. This is
none of what is in the staff report is addressing 3.2.4.
Is what?
I'm not addressing 3.2.4 anywhere in my response to this appeal.
I'm sorry, I'm having really trouble hearing you. There's some noise going on. I'm not sure what it is. Would you repeat one more time?
I never addressed 3.2.4
okay.
in this appeal, so I'm not even arguing that.
Okay.
And I think Mr. Black has his hand raised again.
I see that. I'm going to call on Mr. Black next, and then I'll go back to Mr. Lawson. Mr. Black?
Yes, thank you. I just wanted to make the point. I mean, I think the 3.2.3b is crystal clear in, in that reduction in area is what triggers the need for the variance or use permit. But I think that the key here is in both of these is the phrase "except in conformity." So when we talk about, you could never reduce open space, that's simply not the case, or lot area. It's when you do that and you have nonconformities, because when you don't have, and that's what the purpose of that phrase is. So the except in conformity is really the issue, and so I just wanted to add that. Thank you.
Thank you, Mr. Black. Mr. Lawson?
Yeah, what I was going to say is, if we're going to not allow a reduction of a lot, why would that be put in lot area minimum? And why would it? Because that's requiring the minimum lot area. And it just doesn't make any sense that when we have a huge lot, we can't reduce it based upon a non-conforming situation that exists currently and has existed for many, many years. I think the only way you can make sense out of this and make sense out of the grandfathered language is that you can't go below the minimum lot area or below the minimum lot width. You can't affirmatively create that situation. Otherwise, you can't ever, encroach upon open space. You can never reduce a lot.
Okay. I have a question for Ms. Vaughn. Ms. Vaughn, so your position is that the appellant, Ms. Hunter, would require a use permit?
To re-subdivide and make the lot smaller, yes.
So a use permit to subdivide.
A use permit to allow the creation of a new lot that has structures that don't meet the setback requirements.
They do meet, oh, the side setbacks.
Yes.
Okay. So the use permit would just be on the side setback, have nothing to do with the non-conforming lot width.
No, that was addressed and say that a variance is requested for that.
Right, but we're saying that that's already been denied.
Some are
So,
saying that,
I'm
some
just,
are not.
okay,
Yes.
so I'm trying to understand if this comes to the BZA, what options does the BZA have? In either, I mean, if we deny this, then the subdivision doesn't go forward?
They have the same options they had before they filed the appeal, which is to apply to the BZA for a variance and for use permits.
But they don't need those unless the subdivision goes through.
The subdivision would not be approved unless that happens. So if this came through for a subdivision request to DES, the zoning review would have these notes as saying these are the issues from zoning's perspective with approving this re-subdivision request.
And on what basis would the BZA deny a variance?
I mean, that's not really my.
It's all the usual criteria, Madam Chair. You know, we would just apply the normal rules. So is this a unique situation? Is it repeatable? Is it does it meet the hardship requirement, or is it an unreasonable burden on this particular property? It's all the usual things. And Mr. Lawson has asserted, and I think he's probably right, that it would be a slam dunk to grant the variance.
Oh, there are no slam dunks.
And then the subsequent use permit would be to allow an existing condition.
On a new lot.
On a new lot. Any of the other colleagues want to weigh in on this?
Madam Chair?
Mr. Melnick?
Yeah, so I can see the logic with the zoning code. You know, if a lot is shrinking, you know, that you know the ordinance is meant for the whole, I guess, cramped situation not to be exacerbated, you know, by shrinking a lot. You know, if the building's already or two, you know, within the setback lines. So I can see the logic, you know, of the whole reducing and then needing a use permit just because of the, you know, cramping of that. So I can see the logic in it. And the other thing is, you know, it does sound like there's remedies, you know, granted, you know, if it's a variance or a use permit, but, you know, it just, you know, and we can't say now because the case isn't before us whether that would be impossible, where the criteria can't be reached. But I can definitely see the logic, you know, in what's being argued by the county about, you know, the whole idea if something's reduced, then it's got to be in conformity. So, you know, I can definitely see that.
Thank you, Mr. Melnick. Ms. Freshman?
I feel like I'm a little bit underwater here, but I tend to agree with what Mr. Melnick was saying, just in terms of the apparent remedies. Frankly, I find it confusing, but I do think that it seems to me that if the zoning administrator is upheld, there are other options, including coming to BZA. So I don't feel as if it's because of that, I don't feel as if it's you know, a lost cause and we have to sort of to do a jump ball.
Okay, thank you. Mr. Owen?
Yes, Madam Chair, I agree with Mr. Melnick and Ms. Freshman, and therefore there's a majority in favor of upholding the zoning administrator. And for the sake of efficiency, I would propose that we uphold the zoning administrator with regard to both matters that Mr. Lawson has identified as being issues before us. So the zoning administrator may be unhappy that we're upholding her view about whether a variance is required because she thinks it's a matter decided, but at least we're upholding her. And if in the event that Mr. Lawson appeals, she can argue afresh in circuit court that the circuit court has no jurisdiction to decide that question because we didn't. But I do think that rather than defer this for further arguing on the procedural question, it makes sense for us just to specifically uphold the zoning administrator on both issues and let other venues decide if anyone needs to worry about whether or not the variance was properly before us, or the variance question is properly before us. So that's my general proposal for how to proceed. I'm not making a motion yet, but I'm just throwing that out as a way to most efficiently resolve this question.
So,
Madam Chair.
Mr. Melnick.
So that sounds like a very expedient way of handling it that Mr. Owen mentioned. So I would be in agreement with that.
Mr. Owen, how would your proposal change the resolution? Because right now the resolution to affirm and uphold is based on the September 8th zoning determination letter.
Yeah, we'd have to add some language there, which I can scribble out in if you give me a minute.
All right. Mr. Black?
Barnes here.
Yes.
I think you can just reference both the date of both her letters.
What's the other date?
August something.
There's
August
one,
24 or something.
July.
One July 1st.
July 1st and September 8th.
Yeah.
Yeah.
Mr. Black, I don't know if this gives you an ulcer, what we're doing, but I think this is the direction we're moving towards. Ms. Freshman?
Oh, no, sorry. That was the old one.
The old hand.
Old hand.
If it pleases the board, I just wanted to let you know that I was able to pull up the March 16th Supreme Court of Virginia order extending declaration of judicial emergency in response to COVID-19 emergency, and it applies to the district and circuit courts. Now, I understand Member Owen's statement on that, and again, I respectfully disagree. I believe this applies to the circuit and district courts and those courts only. So
the district and circuit courts were enumerated by name. Is that what you're saying?
Yes. Yes.
Okay. Thank you.
Mr. Owen, are you prepared to make a motion?
Yes, ma'am.
Please.
In Appeal V-11601-20-APP1, I move that the Board of Zoning Appeals approve the I move the Board of Zoning Appeals uphold the decision of the zoning administrator and adopt the resolution recommended in the staff report on page 5, but before the final period, add the following language: and upholds the zoning administrator's determination of July 1st, 2020, that a variance was necessary to approve a proposed re-subdivision of the subject property. And upholds the zoning administrator's determination of July 1st, 2020, that a variance was necessary to approve a proposed re-subdivision of the subject property.
All right. Is there a second to that motion?
I'll second.
Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Ms. Clark.
Aye.
The chair votes aye. The motion to uphold the zoning administrator passes on a vote of 5-0 with the modifications in the resolution as made in the motion. Thank you.
Yes, thank you for your
Thank
time.
you. Thank you. Appreciate your time.
Thank you. Mr. Rissy, still with us?
I'm here, Madam Chair.
Will you call the next item, please?
Next item is case number V-11611-20-VA-1. It is a variance request by Brendan and Catherine Brannon, the owners, to permit a total main building footprint of 30% instead of 28% as required for a one-family dwelling with qualifying front porch in the R10 zoning district regarding a rear porch over existing flagstone patio in the R10 zoning district on the premise known as 3530 North Utah Street. Staff recommends the board adopt the attached proposed resolution denying the variance. An alternative resolution and conditions have been provided should the BZA see fit to approve the application as advertised.
Thank you, Mr. Rissy. Any questions for staff? All right. Can we hear from the applicant, please? Mr. Brenda and Catherine Brannon.
Correct. Thank you, Madam Chair. Thank you, members of the board. We appreciate the opportunity to discuss our application with you and all your time and efforts. Hopefully, as you've seen from the application and the staff's report, we'd like to cover an existing back patio to create a more functional and usable outdoor space that leads directly to the main family room of our home. In our case, we think a strict application of the main house limit would not account for the unique layout and topography of our lot. The exception that we're seeking is a less than 2% exception to the main house limit, so it would be a total of 29.53 versus the 28% limit. In particular, there are, I think, 5 factors that we feel support our application. First, we would remain with this project still under the 35% lot coverage limit, and we're not seeking any exception or variance with respect to that provision. What this means also is that we could build a structure or even a slightly larger one of this size on our property, but only if it was detached from our home, which is not something that we think would be the best outcome for our lot or our neighbors. Second, we're not seeking to decrease any existing setbacks on our property. I suppose that's probably a rare characteristic of any main house limit variance. It's a function of sort of the somewhat unique layout of our home. With the layout of with the topography of the lot and where this proposed covered patio would exist, the area is not even really visible to all but one of the 7 adjacent properties. It's really tucked back into the back corner of our home and lot. Third, the area is already a patio. It's a flagstone patio, and so the project would not increase the total non-permeable lot coverage that's already in existence today. And in fact, we're planning to build in a planter box that would capture the rainwater from half of the roof, the shed area from the roof. Fourth, we have widespread support from our neighbors. We have submitted letters of support from all of the immediately adjacent neighbors and 8 other neighbors that are in very close proximity to our home. And fifth, there's no change in use or zoning classification impacted by, or implicated rather, by our application. So in summary, we very much appreciate the board's consideration. We feel the application is for a limited sensible, reasonable improvement to our property that's not to the detriment of any of our neighboring properties, and that a strict application of the main house limit in this instance would not account for really the limited nature of the project and the unique layout of our home and the topography of our lot. So we're happy to answer any questions, and we appreciate the board's consideration of our application.
Thank you, Mr. Brennan. Mr. Rissy, are there any speakers on this that have signed up? No speakers, thank you. Any questions for the applicants? All right. So, Mr. Melnick.
Okay, so the topography, so the applicant is stating, mentioning topography. And the thing about topography, how that becomes relevant is under the analysis of hardship, whether a variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, which existed upon the effective date of the zoning ordinance. But my question to the applicant would be, in reference to the topography, is he claiming that there's a hardship in some manner?
So thank you, Mr. Melnick. With respect to the topography, which you perhaps can't see from this picture, but from maybe the sort of the bird's eye picture, the homes behind us, which are on Upland Street, so the two neighbors behind us, somewhat difficult to see there, but there's about a probably 30 to 40 vertical foot separation between the homes. The foundation or at grade of the homes behind us are above the roof level of our homes. And so that's really, I think, more a reflection from a topography perspective of the fact that, while they are immediately adjacent to us, they're very separated. And so it's a project that they wouldn't even be able to see, if you will. And we have their full support. So that's where the reference to topography came from.
Okay, so Madam Chair, I have a follow-up question. So,
Mr. Melnick.
So it sounds like in reference to the topography, that is more on the analysis of whether there's a substantial detriment to adjacent property. And so you're saying the topography makes it so there's not any substantial detriment. Is that your point about topography?
I think that's a fair point, and along with the fact that there's no reduction to any of the existing setbacks, yes.
Okay, thanks.
Just to follow up on Mr. Melnick's questioning, the standards for a variance are very strict and are laid out in law. And in order for us to grant a variance, we would have to have some evidence that there is a hardship, that you have something unique on your property that often relates to narrowness, shallowness, irregular shape, or exceptional topographic conditions of the natural characteristics of the property. Some kind of a hardship that would unreasonably restrict the utilization of your property. And I'm not seeing that in any of the materials that we've been given.
Madam Chair, if I may, so particularly with respect to the location of this project in the layout from the interior of our home, which I appreciate you can't see just from these exterior pictures. But the back of our home is the main living area of our home. It's where our kitchen is. It's where our family room is. And while there is a front porch on the home, it's at the front of the home, and the rear of the home has no covered outdoor space for either seating or dining. And so it makes it, somewhat for us and the way we would like to use the home, somewhat impractical, which is why we're seeking to be able to cover this outdoor space at the rear of our home, which is primarily where we live within the home and where we entertain, or would like to when COVID is over.
Okay. Any other comments or questions of the applicant?
Madam Chair?
Mr. Melnick?
So these are my thoughts. And maybe, I don't know if I should wait until the matters with the board. Are there any other speakers?
No, there are no other speakers.
Okay. So my thoughts are very similar to Ms. Freshman's, that, we do have criteria that we have to reach. And the first two are in the disjunctive, but it's whether the application of the terms of the ordinance unreasonably restrict the utilization of the property. So like whether or not approving this would cause an unreasonable restriction. And then it's, or would there be a hardship due to a physical condition relating to the property? But there's, would granting it alleviate a hardship? But we're hearing the hardship. I mean, that there's not a hardship, but that it just wouldn't adversely affect the neighbors. But so the criteria of unreasonably restrict and the hardship, but I'm just not hearing evidence that that would be the case. And also, let's see, the other one would be, the general and that this is not so general or reoccurring. And I think it is general recurring because this is a rather common shaped lot. So it really would take like a zoning ordinance amendment to make, I think that'd be more appropriate because this is like a very common lot. And I know maybe it's frustrating to the applicants because, it's just such a small amount between 28 and 30%, as far as main building footprint coverage. But the fact of the matter is, even if it was 1%, we still have these criteria that have to be met. And so, the fact that it's so close, that really doesn't figure in, per se to the unreasonably restrict and hardship. So, so for me, while it is very close, I'm just not seeing those first two disjunctive criteria of unreasonably restrict and hardship.
Ms. Freshman?
Yeah, I agree. I agree. I understand the desire to cover that area, and it's in the rear and nobody sees it, and what's the big deal, except that variances do have specific criteria, and in this particular case, I'm not persuaded that that it should be granted.
If anybody else wants to weigh in, or I'll take a motion. And we'll see where the board stands.
I'll make a motion. I move the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-11611-20-VA-1.
I second it.
All right, we have a motion made by Ms. Freshman, seconded by Ms. Clark to deny the application for a variance. Is there any further discussion? Ms. Freshman, you have your hand up, but I assume that's your old hand.
It's my old hand, sorry.
I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Unfortunately, the request for the variance has been denied for I think the reasons that were previously outlined, that the standards for a variance are very high, and we are required to actually find that there is a hardship, and in this case, we don't see one, unfortunately.
Okay, well, we appreciate the board's consideration. Disappointed by the outcome, but we understand the process. And having sat through last month's meeting, I would say as well, we're quite impressed by the level of consideration that the board takes to all these matters, and are very appreciative as well of Mr. Rissy and the staff's support in receiving and processing our application.
Thank you for those kind words, and we regret that we had to move you to yet another month after you stayed up so late following all of our discussion.
Thank you.
All right. Mr. Rissy, will you call the next item?
Yes, Madam Chair. The next item is case number V-11617-20-UP-1. It is a use permit request by Scott Tykowski and Patricia Tykowski, the owners, to permit a street setback of 24.8 feet to the wall instead of 25 feet as required from North Henderson Road regarding the enclosure of an existing screened carport on an existing one-family dwelling on a corner lot in the R6 zoning district on the premise known as 4540 2nd Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Are there any questions for staff? Mr. Owen?
Thank you. Madam Chair, or Mr. Rissy, the BZA is required by law to consider whether or not the proposal would promote compatibility with development in the surrounding neighborhood because the overall footprint size and placement are similar to structures on the property surrounding the subject property. And typically, the staff responds to that question with specific information about the footprint size and placement of structures on the surrounding properties. But the written staff report, in fact, here provides no information about the footprint size and placement of structures in the surrounding properties. And I'm wondering about that. The staff answers a different question than that one. But did staff do an analysis? Did the staff look for information about the footprint size and placement of similar structures on the property surrounding the subject property?
I would say that the analysis that staff did is in the report that we've given you. I don't think it's always the case that we look for both of those items, and this was a unique circumstance where the footprint size and placement of the structure aren't in fact changing. They're just looking to change a unenclosed structure to an enclosed structure.
Thank you. Does Arlington County have a policy that encourages unenclosed front porches?
This is a question you've asked before, and Arlington County does not have, and the answer I've given before is Arlington County does not have an explicit policy promoting unenclosed front porches. However, the zoning ordinance does give a coverage benefit to properties that do provide one.
To the extent Arlington County encourages unenclosed front porches, what is staff's view regarding proposals to convert unenclosed porches into enclosed building additions with the same extent?
Porch.
I don't know. I guess I would say it seems to me to be a porch. It's a covered porch.
It's a carport.
There's no car in it. There's furniture inside it.
Well, that was.
It used to, well, perhaps it was at one point a carport, but it isn't now. It's got lawn furniture inside it. It's an outdoor living space, just like other porches are.
May I speak? This is Scott Tiskowski.
Oh, wait a minute.
I'm
Not your
sorry.
turn.
Okay.
Not your turn. We're in the process of asking staff for questions. Let's get
Yeah.
through that.
And just so the applicant understands, this is really about the information that the board gets from staff and the consistency of the analysis that we get from staff. So I can understand the applicant feeling a need to exercise some patience with these questions, but I appreciate that patience. So once again, to the extent the Arlington County encourages unenclosed front porches, what is staff's view regarding proposals to convert unenclosed porches into the enclosed building additions with the same extended footprint as an unenclosed porch? Are such conversions always consistent with county master plans, land use and zoning related policies of the county, simply because they are conversions that do not affect the footprint size and placement? If not, how should the BZA consider when a conversion of an unenclosed porch is or is not compatible with such policies?
I would say that staff doesn't have a general view for the enclosure of unenclosed porches, more than they have a view on any other addition. I would say that, you know, we look at the case on its own merits, and we would recommend the BZA does as well.
Okay. If a future owner of this parcel requests to add an unenclosed porch or a stoop that even further encroaches on the Henderson Road side, because other neighbors have an enclosed porch or stoop and we do not, or because the structure, having once been a porch but now being an integral part of the house, needs different access from Henderson Road, should the BZA take into consideration that a by right unenclosed porch at this location was previously enclosed? See, for example, and I provided a case number to you in writing, which you may have had a chance to look at, on 19th Street South, in which the BZA approved the enclosure of a front porch in 1968. And then in 2020, new homeowners requested an additional front porch on the porch that had now been enclosed with a further reduced setback, in that case of 12 feet. So the question is, does the fact that they took what was an unenclosed porch and made it enclosed affect analysis of whether or not they should have an equitable consideration of additional unenclosed front porches in front of what's now an integral part of the house?
If it's a part of the history of the project that the BZA thinks is important to the case before them, I think it is something they should consider, but I can't speak to a hypothetical potential for a new porch to be added to this structure at this time.
Okay, thank you. Oh, and the final question is, no, I'll wait with both my other questions. Thank you. I appreciate that.
Other questions for
Thanks
staff?
to the applicant for the patience.
I have a couple. I have a couple questions. In the conclusion, it states the regulatory nature of the request, and I'm not sure that's a phrase that I've seen before, and I wondered if you could explain what that means.
I believe the staff member writing the report was referring to the fact that an unenclosed porch is given a 4-foot encroachment allowance, and in this case, they are looking to convert what is given a 4-foot encroachment allowance into a structure that is not given a 4-foot encroachment allowance. Again, not an addition of the actual footprint or change in the setbacks of the structures, but a change in what is a permissible to an impermissible encroachment allowance.
All right, you called it a porch. And but in the subject line, it's referred to as an existing screened carport. Is that a thing? I mean,
I think it is in this case. I don't know that I've seen one before, but I think we have one here tonight.
So is this a porch or isn't it a porch? Does staff have an opinion on that?
I think it was probably originally built as a carport. I think it is currently functioning as a porch, as it does have screening on 3 sides.
Okay, that's helpful. And just this kind of nit, but in the staff report, in the comments from the neighbors, it indicates that there are none, but we do have a petition attached in the staff report that has signatures. That just for the record. All right. Any other questions? Mr. Owen? Do you have your hand up? All right,
I'm sorry, Madam Chair, that was a stealth hand.
that's a stealth hand. All right, let's hear from the applicant. Scott and Patricia Tyskowski.
Yes, we're both here.
Do you have your video on?
Oh, no, sorry.
You don't have to, but if you have it, you. All right, welcome.
Thank you.
Would you like to make a statement on your application?
Maybe just clear up some of the confusion. The reason we had this issue is because the 1967 plot labeled it as a carport. This house has been in my family's name since 1966, and it was a closed-in porch and used as a porch before I was even born. And I guess there's an exception to the 25-foot rule to porches that were screened in prior to 1976. So there was no way I could prove that happened before 1976. Just my word that it always has been my entire life. So there's been a lot of confusion over calling it a carport versus a porch, and it's only because the 1967 original plot that the county has calls it a carport. Like I said, we're not looking to change the footprint at all. We have screens and I guess outside screening material and we just want to replace those with some frames and windows to make it a all year room for us. Considering I am now working from home, my wife teaches from home virtually, and our sons are learning virtually, even going hybrid. We really need the space.
Okay. Thank you. Any questions for the applicant?
Madam Chair.
Mr. Owen?
So first, your one of your neighbors about 5 doors down on Henderson came before us for a use permit earlier last year. And since they were across the street from the Arlington Assembly of God, they asked the church to weigh in. And I'm wondering, since they're your backdoor neighbor, if you also asked them about your application and what you heard back from them.
I hadn't thought of asking them. Like I said, we've known them for years. They let us use their back parking lot. We have a very good relationship with them. We also don't see them very often anymore. It's not a real crowded church anymore. So I'm not even too sure who I would even speak to. Most of the church activity is down at the other end of their property on Pershing Drive. So we have very little interaction with them.
Yeah. So did you receive a question earlier this week asking about feedback from them?
I did. Mr. Rizzi sent me an email with the questions that were going to be listed. I didn't take that as I should go speak with them.
Okay.
We also thought that just because where the proximity to the church behind us is really just the parking lot. It's not actually where, and that part of the parking lot is actually almost never used for the church. It's pretty empty.
So you were assuming that they wouldn't care?
I'm sure they wouldn't. I know Pastor Lynn, who also lives on this block. I haven't seen her in a long time, but we've had she's been a friend of the family for years.
And what about Culpeper Gardens Apartments across the street from you?
So again, that's I never even considered them a neighbor because we are right across the street from their wooded area. So it didn't strike me to have to get the statement from them.
Those are very understandable perceptions. So I don't want you to feel like I'm beating up on you with the next question I'm going to ask, but we're just trying to work on this as a general matter for the BZA. So we provide applicants now with a 2-page statement about community outreach, and it has a diagram that shows the adjacent neighbors. And it even specifically mentions, I think, churches and other institutions in it. And so I just wanted to see, did you find that unclear as to our expectations for institutional uses, or was it that you didn't read it carefully or you didn't understand it? And again, I'm not trying to embarrass you or beat up on you, but as we try and improve our own procedures, I just want to think about how we can improve our communication with future applicants.
Sure, I don't think either we missed it or it wasn't clear to us. And even if you look at the photograph, the plot, we kind of only have one real neighbor. So when we were trying to get letters, we were kind of even stretching to get the neighbors that we did have sign the letter. So whether fortunately or unfortunately for the community's sake, we don't really consider Culpeper or the church members of the community that we thought to look out to. Right. So that was not clear to us.
Okay, well, we'll review that document to see if we can be clear about that. So my final question does relate to the missing information in the staff report. So as you heard me say, we're required to compare you to your neighbors with regard to this footprint and setback of your proposal. So if you did not already have a carport there, but you were just asking for an addition in the same place, there's no question that we would have to apply this analysis. So staff is saying we don't have to do it because there's already a carport there. I'm not sure I agree with that, but another way of attacking the problem is to go ahead and compare you to your neighbors. And if you're similar to your neighbors in terms of placement and setback from the street, then we can still approve you, right? So now my question to you is, do you have any information about whether or not any of your neighbors' houses are closer than 25 feet from the street? For instance, any of the neighbors across the street or one or two houses down from you, do you know one way or the other whether you would be the only neighbor around you that's closer than 25 feet, or are there already some others?
Well, you had mentioned our neighbor on Henderson Road that had contacted the church. So I think they've completed their construction, so they must be within 25 feet. Other than that, I can't say for sure, no. This was also kind of confusing for us too, because originally when we were turned down, it said, you know, we had read that we needed to be 25 feet from Henderson Road. Mm-hmm. And I was like, you know, I went out there with a tape measure and I'm like, okay, we're well over 30 feet from Henderson Road. I didn't realize where our property line was when it went through there. I also don't know that about my neighbors.
Right.
So if I look right across the street, yes, I look at my neighbor and he looks awfully close to the street. But I don't know exactly how far, and I don't know
where his property line is.
I don't know where his property
is. Right, exactly. That's a good point, that we usually measure from the formal property line and not from the curb. So I can see how that would be confusing. All right, well, I appreciate that. And I know that these are kind of legalistic questions, and mostly the discussion I'm needing to have is with our staff and not really directed at trying, again, to get you on the hook. I mean, the fact is you're only proposing something that's a foot or two over the line. And yeah. So I understand it's tough to be patient through all these questions, but I appreciate your patience. Thank you.
Thank you.
Any other questions for the applicant?
Motion?
Ms. Clark, do you have your hand up? You're muted.
I was going to ask the applicant, Madam Chair, if there was any outreach to the neighbor at 4600, which is across the way.
There was. We went several times and knocked on their door. They happened to be renters, and we just didn't have the contact information for the owners. So I did stalk our neighbors to try and get signatures, and I could just never catch them.
Okay.
Thank you, Ms. Clark. I'm glad you asked that question. That's another part of our instructions, is that we do give instructions on how to reach the owners when it's a rental property. So we'll have to work on our instructions to make that clear, but it is possible to actually contact the owners if necessary. Ms. Clark, you have your hand up, but you need to put it down now, right? Okay. Anything else? Are we ready to move forward?
Motion?
Ms. Freshman?
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11617-20-UP1, subject to the condition and with the additional condition of a 3-year limit.
I'll
Thank you.
second it.
Seconded. An additional condition number 2 on timing, seconded by Ms. Clark. Any further discussion?
Yes, Madam Chair. I was very disappointed not to have the critical analysis in the staff report. I'm going to vote for the motion because I visited the parcel in person and made some visual observations. And as the applicants pointed out, there is a record just a few doors down of a encroachment near the street. But I think that staff's analysis just completely missed the question that we're required by law to ask. And moreover, I think moves in the direction opposite of what county policy is, which is to promote unenclosed porches. And it is not county policy that you can build an addition where you otherwise could not, simply because first you built it as an unenclosed porch and then you enclosed it, doing that multi-step process. And in the past, I don't know if Ms. Vaughn is still here, but in the past, I specifically asked the zoning administrator, we have these situations over and over again where we have the porch on the porch that was previously enclosed, and then people say, well, I don't have a porch and my neighbors do, and it's because they previous owner enclosed the previous porch. And so I remember a couple of years ago, I specifically asked the zoning administrator, what's the point in this cycle where we should be strict? And she said, well, the point we should be strict at is when the enclosure happens. And because I think that this should be approved because of its size and placement, I'm willing to vote yes on this motion. But I think that the staff's analysis in this report is just exactly the opposite, not only of what the law requires, but what county policy is. And I just want to express that very grave disappointment. And I hope it is not repeated in future staff reports. Thank you.
Thank you, Mr. Owen. Or any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to grant the use permit carries 5-0. Your use permit is approved.
Thank you so much.
Thank you.
All right.
Much appreciated.
Take care. Mr. Rissy, will you call the next item?
Next item is case number V-11618-20-UP-1. It is a use permit request by Maureen D. and Philip and Corrigan, the owners, to permit a rear setback of 13.5 feet to the porch, 12 feet to the porch eve.
Yes.
From the rear lot line instead of 21 feet to the porch, 19.5 feet to the porch eve as required. Regarding new elevated one-story rear porch on the single-family dwelling in the R10 zoning district on the premise known as 4436th Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rissy. Any questions for staff? Mr. Rissy, I just probably know the answer to this, but the plat shows that this property has a basketball court.
Yes, Madam Chair?
And that does not enter into any coverage calculations, correct?
No, Madam Chair. I believe it would be viewed as an at-grade patio, which is not counted towards coverage.
It's at-grade patio. Okay, thank you. Is the applicant Maureen and Philip Congren?
Karin.
Karin?
Hi, we're here.
Thank you. Where are you? I'm looking for you. Do you have your video turned on?
I do. Can you not see it?
I don't see it yet. Now I see it.
Oh, yeah. There it is.
Go.
Okay.
Welcome.
Excellent. Thank you.
Do you have any comments you'd like to make on your application?
Yes, and before I begin, we also have our architect, Paul Arquette, with us. Will he be able to speak? He just has a few technical points to make after I speak.
Mr. Rissy, did he sign up?
Madam Chair, they're saying that he's authorized to speak for them.
I'm just saying, yeah, you'll have to collect his information.
Okay.
Okay, go ahead.
All right, thank you. So very briefly, first of all, these are beautiful photos of our house. Thank you. So very briefly, we are looking to build an outdoor covered and screened porch, screen space where we can get together with family and friends in the warmer months. Our 2 adult sons and our daughter-in-law, we would just like to be able to get together with them since we really can't get together with them in the house these days. We don't want to tear down our large deck. That would allow us to put the porch closer to the house, but we don't want to destroy truly lovely deck actually and send the wood decking to a landfill. Putting the porch on the south side of the deck, that would be where that kind of gazebo structure is right now. That's the only other possibility. That would block our views from the deck into the backyard, and it would make the deck less accessible from the yard. All the neighbors are, except one, and that's that house under construction. You can see kind of in front of our house actually there, beside our house. They're over 100 feet from the porch. That's my estimate of the neighbors on the other side of the park. If you look at, yes, thank you. So we are at the very end of the upper portion of Broyhill Forest Park. And we have just the one neighbor to the left of our house now, looking at that photo from above. And then the house to the right, that house has actually been torn down and there's a new house under construction. So we got letters of support from all 9 more or less adjoining properties. 5 of the properties are on the other side of the park. We also got a letter of support from Jane Rudolph, who's the Director of Parks and Recreation. We have a letter of support from the Old Glebe Civic Association. And that is my statement. Paul Arquette, so he's our architect. Stephen, you said I need to provide you with his information before he could speak. Is that correct?
He needs to provide it to us so that we have it for the record.
Okay, fine. So can we turn it over to him at this point?
Yes.
So Paul, are you still there?
Mr. Arquette?
Mr. Arquette, you're on mute. Oh, now you're on mute and we still can't hear you.
Mr. Arquette, can you try again?
Unfortunately, it looks like he has removed the mute, but I still can't seem to hear him.
Mr. Arquette, if you can hear us, you might want to leave the meeting and try to come back. And in the meantime, we'll see if we have any questions for the applicant.
Sure. And Paul, if you can hear us, you can also, I think, use that phone number. And let me just send it to you again right now. Here we go. There you have it. There we go. I just sent you the phone number and then maybe you can just call in. He also gave me his comments earlier, so after you asked me questions, I could look them up and read them to you if that would work. And I'm here with my husband, Phil Curran.
Thank you. Thank you. It doesn't look like we have any questions of you. Do you know what your architect was going to contribute to our conversation?
Yes. Yes, I do. So I didn't print that out, but I can just, if you'll give me just a moment here, I can search for that. I think he's on a Macintosh computer, so I don't know if that that would make a difference. All right, so I think I'm getting it right here.
Madam Chair,
Mr. Owen?
do we have any other speakers, such as neighbors, on this?
I didn't see any other speakers.
I'm prepared to make a motion to approve the use permit. So if the applicant's willing to forego the additional commentary, perhaps we could move this along.
Sure, I did find them, but if we don't need them, that's perfectly fine with us.
Okay, Mr. Owen?
Madam Chair, in case V-11618-20-UP-1, I move that the Board of Zoning Appeals adopt the attached resolution approving the use permit subject to the conditions listed plus an additional condition with a 3-year limitation.
Second.
All right, we have a motion to approve adding a third condition on timing. I see that Mr. Yarkett has joined us, but I don't think you're muted. Can't hear you.
So, Madam
But
Chair,
we don't need his testimony.
I would just say I really thank the applicants and their architect for a very thorough packet, which was very helpful to moving this along quickly, and that was much appreciated. And I hope that you appreciate a quick approval of your project.
Yes, we certainly do.
We do.
And I also want to thank Stephen and all the staff, Mark, everyone else. You've just been outstanding to work with, so responsive, provided excellent guidance. This was a lot of work to put this together, and I don't think I could have done it without your great support. So thank you.
That's very kind of you to say so. Mr. Owen, who was your second?
Judy.
Ms. Freshman. All right. If there's no further discussion, I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to grant the use permit passes 5-0. You have your use permit.
Wonderful. Thank you all very much.
Right. You have a happy architect.
I'm sure we do. Yes. Thank you very much.
Thank you.
Mm-hmm.
Next item, Mr. Rizzi. I think, yeah, this is.
Next item is case number V-11619-20-UP-1. Is a use permit request by Corey L. and Mary J. Bradley, the owners, to grant a street setback of 17.5 feet to the porch, 16 feet to the porch eve from North Garfield Street, and 12.2 feet to the porch, 10.7 feet to the porch eve from First Street North instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from each street. To permit a street setback of 12 feet to the rear addition, 10.5 feet to the eaves from First Street North instead of 25 feet to the wall, 21 feet to the eaves as required, and to permit a street setback of 14 feet to the window well from First Street North instead of 21 feet as required. Regard proposed two-story addition with front and rear porch to an existing one-family dwelling on a corner lot in the R6 zoning district on the premise known as 102 North Garfield Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Any questions for staff? Mr. Rizzi, I don't see tables in the, am I missing tables and analysis in the staff report?
I don't believe you're missing any tables or analysis in the staff report, Madam Chair. Everything we have as far as analysis is in the staff report to my knowledge.
So why the departure from our usual format here?
Departure from who was writing the reports.
So it's an individual decision as to how the report is formatted.
Correct.
Okay. I'm given. So how do we know, I guess what I don't understand is how do we know the basis for staff's conclusions?
I mean, I think that we still did provide analysis, and I think that it is there in the staff report for you. I don't think that we're making any great leaps to come to a conclusion without analysis in this case.
Madam Chair,
Mr. Owen,
we're required to evaluate whether the footprint size of the proposal is similar to the footprint size of those in the surrounding properties. What is the footprint size of the proposal?
The proposed footprint is 1,646 square feet.
And
is that
what
in the staff report somewhere?
In the application, Madam.
Okay.
And what is the footprint size of the parcels surrounding this property?
I don't have a footprint size of any of the parcels surrounding this property.
So how should the BZA go about comparing the footprint size of this property to the surrounding properties?
I think that staff looked at the surrounding properties, provided an analysis, and I don't think that it's unusual. I think that the BZA has been approving use permits without a required table for footprint size since they were originally adopted in 2007.
I'm not asking for a required table. I'm just asking if you have any information about footprint size from the surrounding properties.
Everything I have is in the staff report.
And so how do we compare how should we compare the footprint size? There's a lot of discussion in the staff report about placement, but I didn't see any discussion in the staff report about footprint size. So I'm wondering what in the staff report, or what information is staff providing any information to us to allow us to compare the footprint size of this property to the surrounding properties?
I don't have anything other than what's in the staff report.
Okay.
Is there? All right. Ms. Rizzi, do you understand our dilemma here?
I understand that you're asking for something that wasn't provided. I don't think that it is a requirement. I think that we have come to a reasonable conclusion and recommendation. I think that the BZA can choose to agree with staff's recommendation, or they can choose to look at factors that they think are different and deny the application.
Well, I mean, I don't think we would deny the application for lack of analysis. I think we would have to defer and find out, a way to get the analysis. If
I'm sorry, Madam Chair.
I guess we would request that staff do the analysis, or that we figure out another way to do the analysis. But I don't know how how else to proceed.
Madam Chair,
Mr. Owen?
Ultimately, it's not staff's obligation to do that analysis. Customarily, they do perform it, which is a benefit to the BZA and to the applicants. But it's the applicant's responsibility to make the case. So if the applicant is not providing information about the bulk and placement of their property compared to the surrounding properties, and nobody else does, which often staff does in place of the applicant, then the applicant may not have met their burden. So I agree that a deferral to ask the applicant or staff to provide that information may be appropriate, but ultimately staff has no obligation to provide us with that information. They just, they can do their analysis however they want, with or without the statutorily required information. So I would just say if we were going to do a deferral, it wouldn't necessarily just be to put the burden on staff. Staff
Right.
can continue to choose not to provide that information to us. But if the applicant, because they're not being assisted by staff, don't provide us the information either, then I think it might be difficult for us to make the statutory finding that we are required by the code to make.
I think that's well put, Mr. Owen. I know the
Madam
owners
Chair?
have their hands up, but we're still talking to staff, so give us a minute here. Mr. Melnick?
Yeah, so what I would say, and I understand, we're very appreciative of staff and all they do, the hard work they put into this. But I do think that we've gone along, with pretty much, I don't know how long, maybe years, with the format, of the information and the tables and just the various analysis that we're talking about. And so, I think, hopefully that's clear that we've grown to rely on this. And I understand there's no obligation of staff, but it's extremely helpful. I've been extremely happy with the staff reports, but it does seem like there's been a deviation, during this meeting of the formatting and the information we're receiving. And so, and I would just say, we've been, what we've seen has been great, but, it'd be great, just if staff could consider going back to the previous format involving, the full information in tables.
Mr. Rissy, would staff be willing to do that during a deferral period?
We'll take a look at things if the item is deferred, and we'll bring any revisions we feel are necessary.
Well, I guess we'd hate to have this come back and have the same questions, so all right, let's hear from the applicant. Corey and Mary Bradley, are you with us?
Yes, hi.
There you are. Welcome.
Thank you. Good evening, Madam Chairman and board members. Hopefully we can shed some light on the issues that Mr. Owen has raised and meet our burden to not have this deferred and get to an acceptance of the variance request. We've brought, what's that? Oh, the use permit, sorry. So we're the homeowners and we're also the applicants. We've lived in the neighborhood for 12 years and in this home for 10. Our home is about 100 years old, and it is it has some fundamental structure problems, some functional issues, and also some structural things that we want to address. Our addition seeks to improve both functionality and for both of us. We're both disabled veterans. We anticipate in our long-term future probably requiring in-home care and support, and so this addition will allow us to do that. We think the request also, as I say, improves functionality, but it also will conform with the architectural conformity of the neighborhood. It allows us to preserve trees that if we were forced to go into the by right area, we would have to remove. And we also think it's consistent with recent approvals from the board on properties that you can see in the photographs that were recently approved within the last year. We think our addition doesn't encroach further on the current setbacks beyond what the house already sits on. I know it's challenging to see because First Street that we have on the right side of our property on the west side of the property. At the bottom there is deceptive because it is a narrow street, and it looks like the property reaches further to the south. Again, I don't know if there's anything in particular. If you wanted to find some of the percentages that Mr. Owen was concerned about, I think if you looked on the plat in the upper corner of the notes, it provides the percentages that the current main building footprint has to include what the main building footprint would be with the with the addition. It provides what the garage is, what the driveway is, and what the current building is. So that's, I guess, one place I would turn if that answers the questions you have. I think from the photographs as well, you can see a comparison to our neighbors. If you look at the house that was built in 2017, just the inside lot there, right above us, it's a white house with a black roof. He has the same lot that I have, but he has an interior lot. So I have about 9,000, I want to say 9,082 square feet. He has about maybe 10,000 square feet. So I think maybe just a touch wider than mine. But so that's a comparison of other homes in the area. If you look at the house further on, you can see that one as well has a smaller lot, but another large house. And if you look to the house that goes, my house faces on the right side, Garfield Street. But if you go to the rear street, which is Highland, you'll see the small house that's a brick house with a white bottom, and you can see with the white picket fence. But that house has the setback, the use permit, and it is further to First Street, and it in fact goes, I think, and it says it in the staff report how many feet closer to First Street inside the setback. That I think it's about 8 to 9 feet, and ours again is 12 feet and 10 and a half feet to the eaves. So I don't know if that answers your questions. I guess I'll stand by for questions from the board.
Thank you, Mr. Bradley. The difficulty that we have is that, we deal in actual numbers and usually, and so it's hard to make evaluations sort of in a narrative way. But I'll stop there. Any other questions for the applicants?
Madam Chair.
Mr. Owen?
A couple questions. You mentioned tree preservation.
Right.
And that's helpful that you mentioned it because preserving trees and foliage is another one of our statutory criteria.
Mm-hmm.
And typically, when someone is saying that they're asking for a use permit to avoid removing trees and foliage by right, or we will often ask for some specifics about that. So can you describe where the trees are that you would have to remove with a by right addition?
So the lot is narrow, and I don't know if my pointer can shows it right. Yeah, keep going out toward Highlands. Right, keep going. There, stop. There's a tree right there, and then there's one closer, further up. There's two. There's one. No, the other direction. Going toward the toward the property line, to the back property line, the inner property line. Yeah, right in there. There's another tree. So those two trees would if we because we would have to make the by right addition much more narrow and longer. It would push further out into that green space. So those are the two trees that would be affected by doing it by right.
So if one of the justifications for a use permit is the preservation of trees and foliage, we will sometimes ask the applicant if they're willing to have a condition that they'll maintain or replace trees in those locations. So is that something that you would be willing to commit to? To
replace trees? So I don't know how long. I haven't. We seek to dig a basement. I guess if. So I haven't done any studies on the trees. I don't think they're in any impact under the current design. So I guess we'd be willing to do that. I just haven't given that any thought. If replacing of the tree is adequate, so if in the process of digging the basement we had a tree not survived, I guess I'd be willing to replace trees.
Yeah, I think that's just the idea. Like we won't require, it's a living thing, right? So we can't require you to keep it alive. But the idea is that either you have that tree, or if it dies, you'll put another tree in its place.
Sure.
But that way we're not approving something for the sake of tree preservation, and then like the next year someone cuts down the tree, right? Or you sold your house and the next owners, that's the idea. So it sounds like that would be something you'd be willing to entertain.
Of course.
I don't see the trees the trees don't seem to be depicted on the plat though. So, so that might be something that we might want to look in with more specificity. Oh, and this seems to show the two trees in this picture.
Right
the two
there
trees on the left there.
and there, right.
Okay. My next question is the street, is that First or Second Street? That
First
above
Street.
your house? First Street?
First.
Is First Road or Street?
Street.
First Street. Is that street a one-way street or a two-way street?
It is a one-lane street, but it's two ways.
Okay. And the curb at the back of your house that just separates the street from the trees, right behind the street there, close to your side of the property.
Right.
Are those county-built curbs, or are those maintained by you?
No, those are maintained by me. They're just removable landscape pavers.
And have you entered into any discussions with the county about the possibility of, since the county hasn't been using that part of the street for decades, of them abandoning the street and granting you the property for you to use private?
No, I have not entertained that or had any conversations with the county. I will tell you though that recently on Highland Street, the street that is, the property, the other direction.
Yeah.
That's Highland. So they are putting curbs in there and making a turn onto First Street from Highland, and that curb that they are going to put in currently will set the current width of the road. So they don't seem to be putting it in. It will maintain the current width of the road. So maybe it's worth entertaining that in the future, but I haven't pursued it as an option yet.
Interesting. So they're gonna, the place that's the public property that your neighbor has fenced in as part of their private yard, the county is gonna put a curb that respects that
Yes.
private use of public property.
It is not going to there's no, I don't know how to describe it. It is going to remain a single lane road, a single width road, right? Not push it back into to its by right, the county's by right. And they've also just recently moved all the telephone poles along there, which which may also set the width of the road, which wouldn't allow for it to go to the by right width.
Yep. All right. I'll just say, because there might be more questions that we have in discussion, like one of the previous items you saw tonight.
Mm-hmm.
I don't want you to get the impression that your in my opinion, just speaking for myself, that your application is ridiculous or unreasonable or whatever. But I have some very serious concerns with our process and our analysis under the law here. And so I just want to point out to you that it's not because I necessarily think your proposal is fundamentally outrageous, but that we have some legal duties here that we have to figure out how to perform them responsibly. And so I just wanted to alert you to that. Thank you.
Well, and I appreciate that it's our responsibility to provide the information you need, and the county staff is just doing their job with the information that we provide. So if there's something else that we need to provide, I guess we can do that. But I guess I am hopeful that we can meet that burden.
I'm sorry, since you said that, I don't want there to be some misunderstanding. In the 5 years I've been on the BZA, hundreds of applicants have not needed to provide certain information to the BZA because staff provided it instead. But you were not assisted by staff in this specific way. And so that's my concern. And so while legally you do have the obligation, historically, as a practical matter, you're not being assisted by staff as other applicants have been, and so that's the issue that I'm addressing. So I don't want you to feel at fault for that.
Thanks.
Mr. Bradley, there was I believe, an architect also on the speakers list. Mr. Rissy, is that right? Can I see the speakers list again? Roger Bohr?
Yeah, our agent who prepared the documents and submitted them to the county. Yes.
Okay.
I don't know if he is on.
Okay. Does he, do you need him to speak, or are you fine with your presentation?
Well, I think our presentation, he has submitted the materials, and so and we assisted him in that. But I don't believe he has anything further that he could probably add to the conversation. No.
Right. Terrific. Thank you.
Mm-hmm.
Board members, any questions for applicants?
Madam Chair.
Mr. Owen?
I have some more questions for staff when you're ready for them.
I don't see any hands up, so go ahead, Mr. Owen.
Thank you. At some point in the past, Arlington County Board changed the zoning ordinance such that required setbacks were measured from the back of the right-of-way rather than from the center line of the road. What was the reason for the county board's change in zoning policy in this regard?
Hold on just a second. I actually am pulling up an answer from one of my colleagues. Trying to pull up an answer from one of my colleagues. As is often the case, we don't have a reason why the county board made the change, but we can give you the history of the change as it's been laid out. Prior to 1950, the zoning ordinance provided for a setback known as building lines from which current street setbacks are derived. The rule at that time was to measure building lines from the center line for right-of-ways less than 50 feet and from the street line for right-of-ways 50 feet or more in width. The standard was carried over and recast as the regulation requiring front yards in our district in 1950, and by the 1970s, the two measuring methodologies were conflated, requiring the front setback to meet the greater of both measures, i.e. 50 feet from the center line or 25 feet from the street. Finally, in the 1990s, the standard for one and two family dwellings was set at 25 feet from the street frontage, i.e. the street line.
Okay, thank you. I had another question, which I think you've answered in earlier in the meeting, but in another case that we deferred, case 11623, staff did present the usual tables for setbacks despite the fact that the property bordered on an alley rather than on another residential parcel. Is there a reason for the difference in approach between the analysis there and the analysis here, which focused on the private use of this public space? And I think when I asked that question on the other application, you provided an answer. So unless you have additional response, I can move on to my next question.
I'm happy to move on.
Okay. Does the Department of Environmental Services deem the current configuration of First Street on the applicant's block to be safe? Do they view the configuration as the inevitable final configuration of the roadway? In other words, is the condition of the road we see now going to be the same as the condition we see in the future?
At this time, I can't say what the final configuration of the road will be. I can say, as the applicant pointed out, that there are changes being made to the turn at the corner, and they are setting up with the existing road width, but I can't say that it will never change in the future.
Okay. We frequently see staff reports in which staff measures from and gives meaning to setbacks from the back of utility easements, underground utility easements that encroach further back than the curb or the roadway. Yet here, staff believes it is more appropriate to measure from the built curb line than from the actual right-of-way. How does staff determine when it is more appropriate to use the legal right-of-way and when it is more appropriate to use the actual curb line in its analysis?
Well, I would offer correction that we don't measure from utility easements. Okay. We only measure from easements for street purposes, which by the definitions in the zoning ordinance are part of the street. And so in situations where that occurs, that is where we are required to take the measurements from. As in this case, it may be in the middle of somebody's yard, and it may be appropriate for us to mention the current setup of the property, as is this case, and we do from time to time, where there are excessive amounts of yard in what is technically the street right-of-way.
Thank you. And then my last question is, if the curb of First Street were in fact located at the edge of the right-of-way for the roadway rather than in the current location, would staff still be recommending approval, or would you be recommending denial of this use permit?
At this time, I'm not prepared to answer that hypothetical.
Thank you.
Any other questions for staff or the applicant? Mr. Bradley, I see your hand up. I wasn't sure if you were coming back or if that's just an old hand.
No, I actually raised it again. Probably, I shouldn't. I should probably just let it go. But I just wanted to make sure that that I guess for me the what sets the idea that it would be approved even if I guess I shouldn't speak for the staff, but the use permit of my neighbor, which was approved in the last year, it seems to me would support the idea that the staff, or at least the board too, would approve a use that was even less than the one that is currently, or that they built. And so I don't know. I offer that just as a point of reference.
Thank you. I appreciate that.
Yeah.
Any other questions, comments for staff? Yeah, I am somewhat uncomfortable moving this forward without some of the information that we normally would rely on, but I'm open to what my colleagues think.
Madam Chair.
Mr. Owen?
I guess the county has a right to build the rest of this street at any time. And staff says they don't know whether or not their analysis would be the same if the curb moves. And so since we can't control where the county puts the curb on any given day, I don't see how we can decide this case without knowing how we would approach it if the curb in fact did move. I think we need to know where our view is based on the possible locations of the curb, and not just where the applicant has put pavers in the middle of the roadway right now.
Mr. Rissy, you have your hand up. Is that new or old? You're muted.
That's new, Madam Chair.
Okay.
I would say that our analysis does include comparison to other structures, as the applicant just stated, that have setbacks that are less than what they are requesting. In fact, 8 feet, I believe, from 1st Street North or 101 North Highland Street. And I would say, regardless of where the curb is, that is a setback that has been approved on a surrounding property. So I think that would continue to be our analysis, regardless of where the roadbed is.
What would your analysis be with regard to building footprint?
I don't understand the question, Madam Chair. Are you saying if there's a different building footprint?
It's got comparison.
Madam Chair, I don't have any additional analysis on building footprint.
Okay. Colleagues?
Madam Chair, there's one other thing I wanted to raise. I happened to catch my eye during the appeal that we had. But in section 3.2.3 of the ordinance, it specifically says, no yard or other space provided about any building shall be considered as providing a yard or open space for the building on any other lot. Now, granted, a street is not a building, but I think the principle there is it's the lot itself that has to provide the yard and setback. That's the principle that's applying here, and usually that's the principle that we use. And I'm just trying to wrap my head around the idea that we're going to say that the temporary use of the roadway as a front yard of a house is going to be the determining factor, the sole determining factor, potentially for approving a setback that might not otherwise be approvable, or a bulk emplacement that might not otherwise be approvable. And I'm not ascribing to staff that exact analysis. I just feel it's an atmospheric that that troubles me. It's not how we usually do business.
Other comments? I don't see Ms. Freshman. I don't see her video, so I don't know if she's still with us.
Here.
Okay, just checking. So how do we want to move this forward?
Madam Chair, often when we do deferrals, we do them for 2 months because there might be a need for re-advertisement or changes in the applicant's proposal. In this case, if we were to do a deferral, I'm not sure 2 months would be necessary, because I think the applicants would be intending to come back with exactly the same proposal. We're just seeking more information about the proposal they've already submitted. So I would just point that out, that maybe a 1 month deferral to try to get some more information on a number of these issues could be helpful.
Madam Chair,
Mr. Melnick?
I would support that, a 1 month deferral.
All right. You want to try a motion? I'm sorry, Ms. Freshman?
I'm not suffering the same angst as my colleagues. I would agree with the staff and approve it. If that's not the predominant thinking, then I certainly wouldn't defer it for more than a month. I don't agree with the discomfort with the road, as although I had a great deal of trouble driving down it when a truck was coming toward me, but that happened when I lived in Vermont too. So it feels like a good project to me, and I really like what they've done, what they're proposing to do, and I have found the information in the staff report to be adequate. I understand it's a different format than some of the ones we're used to with tables, but I still found some of the citations very helpful, and so I'm comfortable with the project. But we'll see what the vote is.
Thank you, Ms. Freshman.
Madam Chair, I move that we defer this to the March BZA meeting.
Is there a second?
I'll second.
And to clarify, Madam Chair, the purpose of the deferral is to seek information from the applicant or from staff, whoever wants to provide it, that compares that compares with specificity the compatibility of development with the surrounding neighborhood because the overall footprint size and place are similar to the structures on the property surrounding the subject property, and would preserve significant trees and foliage. So from the applicant, at a minimum, it would be helpful to have a picture or a plat that shows the exact locations of the trees that are being preserved and some basic description of what they are. For example, their species. It's not very much information. Mr. Rissy can probably help you see conditions we've used for other properties. It's just a few words that we use to describe the trees. So that would be helpful, but showing it on the plat is particularly helpful. And then hopefully staff would provide more information about the overall footprint size and placement and comparing them to the structures in the property surrounding. But it is the case that if staff does not provide that, we'll then be looking to the applicant to make their case. So not sure how that will be resolved, but maybe applicant and staff can discuss who will take responsibility for providing that information. And then it would be helpful if we could get some information from the Department of Environmental Services as to whether or not they are comfortable with leaving the street at its current width, which is very unusual for Arlington County for a two-way street, for the indefinite future. And if we should count on the curb line remaining where it is for as long as the house is where it is. So those are the questions.
Thank you, Mr. Owen. We have a motion made by Mr. Owen, seconded by Mr. Melnick, to defer this matter to our March hearing. Is there any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
No.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to defer passes on a vote of 4-1, with Ms. Freshman voting no. So our hearing is on March 10th. And I hope it's clear from the motion what we're looking for. Don't see the applicant with us. Oh, there they are.
Yep. The only challenge I have is I know you seek certain diagrams or something that the staff typically prepares, and I really don't have access to that and can't put it in a format that might satisfy the board. So I'm just not sure how to go about getting that formatting for the board to make a decision.
I understand. Mr. Rissy, I guess, could you consult with the applicant, and if there's any question, involve me in sorting out who's going to do what?
I don't know that we can talk about the particulars outside of the meeting, Madam Chair, but I'm happy to work with the applicant.
You can't talk to me about it.
Correct.
Okay, if you work with the applicant, that's fine.
I guess, and thank you, board members, for your consideration. I know this after sitting through the tonight's, and I know you got more to do. I appreciate it, and it is hard work. I guess the last thing I would say is where the curb is now really is irrelevant to. I mean, I think the plat that I provided shows where the property line is relative to the street, and it shows where the line would be, and it should give the board members the information if they looked on the plat where the house would be situated on the lot as relative to where the street would be, even if Arlington County decided to expand it. I will tell you that it will be 8 feet from my neighbor's house, and it would be 12 feet from the house that we're proposing, and it will be 12 feet from my current house, because my current house sits with the exact same setback that we're asking for in the proposal. So,
Mr. Bradley, I think your best course is to get guidance from Mr. Rissy. I think Mr. Rissy understands what our issues are at this point, and
Okay,
and
we'll do that.
You can sort that out. Thank you very much.
Thank you very much. I appreciate your consideration. Good night.
Good night. Mr. Rissy, will you call the next item?
Next item is case number V-11620-20-UP-3. It is a use permit request by Jason and Susan Ham. The owners permit a rear setback of 1 foot to the wall and eave of the detached accessory building, bike, garage instead of 10 feet as required from the rear property line, and to permit a separation of 3 feet between a main building and an accessory building instead of 8 feet between buildings as required. Regarding the proposed modifications to an accessory building previously approved by the BZA on a corner lot in the R5 zoning district on the premise known as 1038 17th Street South, staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions, and I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed.
Thank you, Mr. Rissy. Any questions for staff?
Madam Chair?
Mr. Melnick.
Yeah, so I just have a comment, and this has to do with the application done on the new system, but that the agent, Ms. Fife, appears as the property owner. And I just wanted to bring that because I was thinking it pulled it directly from tax assessment information. But, just so staff can be aware of that. I don't know if that was a glitch, or how that happened. But that's all I wanted to say.
Mr. Rissy, do you see where Mr. Melnick is referring?
I believe I have an understanding of what he's talking about, yes.
So the question is, did that come from the real estate record or somewhere else?
I don't believe it came from the real estate record, Madam Chair.
Okay. Right. I guess as we learn the new system, we'll figure out where things are coming from, but we understood in the presentation that property information was being drawn from the real estate record. And we assumed that included the property owner name.
I believe it's being pulled from there. It appears that there is the ability to make modifications, though.
That you can override it. Okay. Okay, that's the question. All right. Thank you, Mr. Rissy. I have a question. So this application is for a use permit. There is an existing use permit that we granted.
Correct.
So if we approve this use permit now, does this site have 2 use permits?
Technically, yes, until the first expires.
Okay.
Isn't it really just an amendment? I mean, maybe not technically, but all they're doing is making a change in something
Yes.
they didn't like in the first place.
Yes, they got approval and are trying to make some very minor changes to it. But it's something that we couldn't approve at a staff level, so it's back as a new application because the original application was decided and approved.
Yeah, to me, it looks like a separate use permit that will be granted with a different number from the other one.
It is. The other one was approved, so we can't reopen or use that number again.
Okay. Any other questions for staff?
Is this the last time, please?
That is not a question for staff. We just take in.
Okay, well, it's an editorial comment. I'm tired.
Is the applicant or applicant's agent with us?
Yes, this is Jason Ham. I'm the applicant, and I also have my agent, the landscape architect Suzanne Fife is here as well. Thank you yet again to the board for hearing our application for the construction of this bicycle shed. The last time we were before the board, as noted, our use permit was approved as we had submitted. However, as we started to lay things out for the construction of the shed, it was recognized that the design as approved was unworkable. And that is what resulted in a new layout in this new proposal that, as staff noted, includes very minor changes to what had previously been approved. And I will turn it over to Ms. Fife to speak to those changes and why they're necessary.
Thank you, Mr. Ham. Ms. Fife, welcome. I think you're muted. Am I the only one that's not hearing her?
No, I'm not hearing her.
Madam Chair, I'll point out that she doesn't appear to actually be muted. Now she is, but it seems to be another situation where when unmuted, we cannot hear the speaker.
All right. Is it best for her to leave and try to come back?
That, or maybe try joining by phone.
Okay, well, sorry, this is Jason again. While we're waiting for Suzanne to join, maybe I can try and describe what the changes entail. As the design was approved, should it be constructed, that would have left an extremely narrow walkway between the stairs entering the rear porch that you see there and the boundary of the shed. The new design as proposed sort of cuts out an L shape in the previously approved design that would allow for more of a clearance to walk on that pathway while still allowing for adequate length to store the length of our bicycles. So it doesn't, it would not provide any adverse impact to the neighbors on the rear or the side. Really, what we're talking about is a change of footprint that would allow for greater clearance on the walkway.
So it's not about being large enough to hold bicycles, it's about the clearance of the walkway?
So we couldn't, it's partly to do with the ability to hold bicycles, because if we just chopped off the length in order to improve the clearance, then it wouldn't be long enough. So that's why we're talking about the L-shaped carve out.
Okay. And is the document that's called Explanation of Alteration, dated January 27, 2021, the design that you are seeking?
So I'd have to defer to Ms. Fife on that.
Okay. Mr. Rissy, should Ms. Fife just log out and come back in? You're muted.
Madam Chair, I just put in, well, she's gone now, so she can't. I was going to say it may be a device settings issue. Whenever you join the meeting, you have to make sure that you use the microphone on the computer, and perhaps that's the issue, but I can't say at this point.
Okay. Mr. Owen?
Thank you. In a previous iteration of this application series, I believe a critical compromise was made to change the pitch of the roof so that the roof is sloping inward from the perimeter of the lot towards your patio. I think in the very first time you applied, you may have had a pitched roof, like a peak roof proposed. But in order to accommodate some of your neighbors' concerns about water runoff, I think you agreed to have the roof pitched interiorly. I can't remember what the old drawing showed, but the new drawings, I don't think very clearly depicts that critical element. And so I'm wondering if you would have any objection to a condition that says, in words, the roof of the structure will be pitched to direct all water runoff to the center of the lot. Would you be okay with that as a additional clarifying condition in the use permit?
Right. So, so I would ask Ms. Fife to chime in if she's been able to join, but since the board approved our last permit that included that pitched roof as part of the design, we have not made any sort of decision to change the plan to unpitch the roof.
Right.
So to my best knowledge, the roof remains pitched. And
Yeah.
for that reason, I would not object to such a condition.
Right.
But again, I would ask Ms. Fife if I'm mistaken.
Okay.
Ms. Fife, are you with us? No.
So I'll just say, Mr. Ham, for your benefit, that we, in between the last time you applied and this time that you applied, we learned that the zoning administrator's view was that if we don't put it in writing, the fact that it was in the hearing record might not be sufficient.
Understood.
And so I just want to be more careful than maybe we have in the past.
Okay. In that case, I would accept that condition.
Thank you.
It's not clear as to whether Ms. Fife is going to be able to join us. Mr. Rissy, you have your hand up?
Madam Chair, I would just like to point out Ms. Fife has rejoined the meeting. It still appears that she is having difficulty with the microphone and we are unable to hear from her. I'll also point out that in the revised drawings that are in the application package, you can note that the elevations, though hand-drawn, do appear to match the same configuration for the slope of the roof as was approved previously.
Okay, that's great. Madam Chair, I'm prepared to make a motion to approve.
Mr. Owen?
I move, where is the motion? I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11620-20-EP-3, subject to the conditions listed with two additional conditions. One, reading the roof of the structure will be pitched to direct water Three, the roof of the structure will be pitched to direct all water runoff to the center of the lot. And the condition number 4, with the 3-year time limit that we've attached to other use permit conditions tonight.
Mr. Rissy, do you have your hand up or is that old hand?
Old hand.
Okay, is there a second?
I'll second it.
Seconded by Ms. Clark. So we have a motion to approve a use permit made by Mr. Owen, seconded by Ms. Clark with 2 additional conditions. Any further discussion?
Are we super clear on which drawing we're using? Is that specific?
Let's look at that. We have an explanation of alteration that has a footprint with dimensions. We do have another drawing in here, don't we?
Yeah. I'd ask you to add after the date in condition number 1, the words title, explanation of alteration.
I'm sorry, could you repeat that, Mr. Owen?
Yes, I'm asking unanimous consent in condition number 1, after the date, to add the words titled explanation of alteration, January 27th, 2021.
Is there no objection? That's included in the motion. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman,
Aye.
Mr. Melnick,
Aye.
Ms. Clark.
Aye.
The chair votes aye. The motion to approve the use permit passes on a vote of 5-0.
Mr. Ham, we should invite you to teach a class on how to be a BZA applicant. You've got an enormous amount of experience.
Thank you, but at this point, I will choose to retire from this particular profession.
Great.
Right. Thank you.
Looks like we have one more item, Mr. Rissy.
Madam Chair, just for clarification in the record, I would like to point out that the next item on the agenda, which is case number V-11621-20-UP-1, was deferred at the beginning of the hearing to a special meeting of the Board of Zoning Appeals on February 24th, 2021. With that
I thought
stated,
this was not one of the four.
This was, I'm checking that myself here.
we have one more item that was not included in that, but we had one item first that was.
Okay. So that was number 8 on our agenda.
Right.
This was number 9 on our regular agenda.
Correct, Madam Chair. Number 8 has already been dispensed of, so we are now moving on to number 9 on the agenda.
Got it. All right.
Which is case number V-11622-20-UP-1. It is a use permit request by William E. Pellenin on behalf of David Pellenin and on Maria Pellenin, the owners, to permit a right side setback of 3 feet to the attached garage, 4.2 feet to the eave instead of 10 feet to the wall, 6 feet to the eave as required. To permit a left side setback of 8.1 feet to the porch, 8 feet to the eave instead of 13.7 feet to the front porch, 13.6 feet to the eave as required, and to permit a right side setback of 7.1 feet to the main building eave instead of 9.7 feet from the side property line as required regarding enclosure of an existing carport, new front and rear porches, and second story addition with new eaves to an existing one-family dwelling in the R6 zoning district on the premise known as 2741 South Ives Street. Staff recommends the board adopt the attached proposed resolution to defer the subject use permit to the March 10th, 2021 BZA hearing based on technical changes to the project in the project scope.
So, go ahead, Ms. Freshman.
I'll make a motion, but I was first going to say that there's so much background noise I followed along with the text, but I couldn't hear you. I move the Board of Zoning Appeals defer the application for the use permit requested in case V-11622-20-UP1 to the March 10, 2021 BZA hearing based on technical changes in the project scope.
Madam Chair, I second the motion.
All right, motion made by Ms. Freshman, seconded by Mr. Owen.
I'd like to speak to the motion.
Go ahead, Mr. Owen.
I had some questions on this item, which hopefully can be resolved during the deferral period. One is that the disclosure document mentions trust ownership, but it does not list the beneficiaries of the trust, which is required when the trust is an owner. So hopefully that will be remedied. And then this includes, I think, a rear setback relief, or maybe it's just side setback relief. But in any event, it's unclear who the owner of the parcel is to the rear of this parcel. It may be a private owner or it may be a public owner. But either way, I think we would benefit from outreach to that property owner to make sure that they have had an opportunity to acknowledge that they know that there is a use permit proposed. So whether it's parkland or a private owner or whatever, it should be clarified who the owner is, and hopefully we can get some kind of feedback from them as an adjacent affected property owner. Thank you.
Before we vote on the motion, I do want to double check is the applicant here, and do they wish to speak on this? Okay, I'm not hearing any. So we have a motion on the table made by Ms. Freshman, seconded by Mr. Owen to defer this matter to the March 10th BZA hearing. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion to defer passes on a vote of 5-0. That is our last case tonight. We have minutes.
Madam Chair,
Ms. Freshman?
I'll move approval of the minutes, January 3, 2021.
January 13, right?
What? January 13, 2021,
Okay.
right?
Yeah,
Okay.
right. We have a second?
I'll second.
I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Minutes are approved 5-0.
Madam Chair,
Ms. Fresh.
could I please ask Mr. Rissy what the March meeting looks like in terms of agenda?
I believe we have about a dozen cases, a little bit more with the deferrals from tonight, including the Islamic Center that has been heard a number of times. So most of the cases before the board, possibly all, will be use permits. We don't have any appeals in March, and
We have some that we bucked from tonight too.
correct.
Okay.
Ms. Freshman, I'll take a look at that and talk to Mr. Rizzi and see if we have a reasonable agenda.
Well, given that we already have a second meeting this month, it's hard to know, but this was a meeting that started out with a whole bunch of deferrals and still managed to go
Right.
to 10:30.
10:30. Mr. Owen, do you have your hand up?
Yes, ma'am. I was just wondering, have we heard any indication that the appeal from last month's meeting has been brought to circuit court or not by one of the parties?
I do not believe it has, at least to this point.
Okay.
Is the time up?
30 days from the finalization of the decision.
What date do you use, Mr. Rizzi?
The date of your decision.
The date of the hearing.
The 13th?
Okay, so there's 3 more days. Is that correct? Is that 30 days?
31 days in January.
Okay. All right. Anything else?
No.
Madam Chair.
Oh, Mr. Melnick.
Yeah, I had a question. So, Judy, Ms. Freshman, mentioned this before, but are we going to get new reports for the deferred items, or should we just keep our paperwork for the special meeting? What will be the process on that?
I'll ask your preference.
Well, it depends on whether there would be anticipated changes or if it was simply a lateral move.
At a minimum, we'll have to update the dates, but I don't anticipate further changes at this point, as the reason for deferral was not due to the analysis, but it's possible, now that there is time for them to be updated, that there will be updates that I am not predicting at this moment.
Yeah, I'm looking.
I think the Cameron Street one is the one that would concern me the most.
Right.
That's one where the additional questions we've asked seems like it'd be most likely to affect the outcome. So
affect the report.
Yeah, I mean, I guess, and conceivably Ohio Street, but more likely Cameron Street. So I think my view is I'm happy to keep what we have, And if all there is additional supplemental material, I'm fine with just using it as a supplement. But if the staff recommendation or analysis changes, then it probably would be prudent to submit us fresh reports.
Understood.
Okay. So we'll hang on to these 4 staff reports. Anything else?
I just want to express thanks to Mr. Rissy and to Chairman Malice for scrambling today on trying to provide some relief to the applicants whose applications had the hiccup with the placards. And that was a lot of extra work for both of you, and I really appreciate the effort that you guys put into that.
Thank you, Mr. Owen. Yeah, it was a rougher day for Mr. Rissy than for me because he was on the front line. But yes, it was a busy day. Our agenda having been complete. So we used the word continuation. Is this meeting being continued to the March 24th date?
I think that's fair.
Let's do that. And that way
I move that we continue this meeting to February 24th.
Can I get a second?
Second.
I'll call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. So the meeting of February 10th is continued to March 24th.
You have to leave the porch light on.
February 24th, Madam Chair, not March 24th.
You're all right. Continued to
Yeah,
February.
bite your tongue. We could end up with that too. The way things are going.
All right. Thank you,
Bye
everyone.
bye.
All right. We'll see you in a couple of weeks.
Pray for